May I Lordship's kind leave and with the leave of Justice Day, Mother, this is the matter for extension of interim order, Mother, in respect of the bench, Mother, where Justice Bhattacharya is sitting with your Lordship.
Extension of interim order, why can't we take up?
This is in respect of a different bench, Mother, Pathat matter, Mother.
Pathat matter. That bench will be sitting soon, probably on Friday. So you hand over the slip. It will appear before that bench when it's Yes,
I'm grateful, my lord. Deeply obliged. It has been Pathat, my lord, and the interim order is till 31st.
Yes.
I'm grateful.
One and two. Yes, yes. Yes.
Lordship, Mr. Dutt was leading me in the matter, Lordship. He was supposed to start with the judgments, but before he proceeds, may I place the terms in the contract, Lordship?
Yes.
May I commence, and as and when he's available,
Right.
I should grant him leave to continue. The first agreement is dated 16th of May 2012, starts at page 111. Volume 1, page 111.
Page 100?
And 11.
11.
Just come back.
Yes. Yes. Let's continue.
Yes, Lordship, page 111, the agreement will, Lordship will find,
Yes.
is between the plaintiff, the two plaintiffs as transferors, and then the defendant number 2 as the company, and the defendant number 1
Yes.
as the other company as transferee.
Right.
What sought to be transferred, Lordship, will now come to clauses D, that is AD, clause AD at page 112.
Yes.
That the company is the lessee of all that the leasehold plot of land measuring so and so in the district. This is in plot number 20 in block DN in sector 5 of the Bidhannagar, Salt Lake City, in the district of North 24 Parganas. This was being sought to be transferred by way of transfer of shares, share capital, the entire share capital. Now, Lordship will come to page 115. Rather, Lordship will kindly come to page 114 onwards. The bottom, right at the bottom, clause B starts.
Yes.
The transferors have agreed to sell entirety of the said shares, and relying on the aforesaid representations, assurances, and declarations of the transferors and the company, and believing the same to be true and correct, and acting on faith thereof, and with the intention of having total control and management of the company, along with all his assets and properties, including the said plot and the said building, and all the rights or interest benefits thereon, free from all encumbrances and liabilities, the transferee has agreed to purchase and acquire the same free from all encumbrances, liabilities whatsoever, for the consideration on the terms and conditions hereinafter contained. Now, this was the purpose of that, was the transfer. Now, Lordships will kindly come to 1.2. Sale and transfer, under the heading sale and transfer.
Yes.
1.2, it is agreed, understood, and clarified that purchase and acquisition of the said shares has been agreed upon by the transferee with the intent and object of having total control, management, and acquisition of the company along with all its assets and properties, including the said plot and the said building thereupon, including all rights, interests, benefits, it
Yes.
elaborates. This was the purpose of the agreement. Even in the at page 124, the arbitration clause. Lordship will now come to page 100 and the second agreement, 135. This is dated 10th of April 2013.
Yes.
The second clause, Lordship, at page 136. It has been mutually agreed by Ms. Dr. Dilip Kumar Ghosh and Srimati Kamala Ghosh and Fun Idea Projects Private Limited, represented by Director so-and-so, that all the terms and conditions of the agreement dated 16th May 2012 will supersede by the following terms and conditions. And thereafter, the final terms of settlement, that the second party, which includes transfer of the second party, Fun Idea, agreed to pay a total full and final settled consideration amount, which includes transfer of share of 27985 shares, which is presently in the name of Recon Engineers India Private Limited, for which they have not paid any consideration amount to the first party, and also transfer of 100 shares of Venkatesh or Medicare Private Limited held by Dr. Dilip Kumar Ghosh, and 85 shares of Venkateshwar Medicare Private Limited held by Srimati Kamala Ghosh, and all the rights in the plot so and so, along with resignation of both Dilip Kumar Ghosh and Kamala Ghosh.
Yes.
Now, Lordship will allow my senior to take.
The reason, Milord, why we decided to take your lordships through these paragraphs in the, because it might come back to your lordship that they are claiming declaration of delivery upon cancellation of these two documents and a declaration that they have obtained by fraud. What we are trying to show to your lordship is that cancellation of these documents would mean cancellation or taking away those rights, which includes proprietary rights in the property at Salt Lake. So that was the purpose, to show that it is directly, Milord, affecting the right title and interest.
Yes.
Right title and interest of the. Now, Milord, the authorities. Milord, there is another thing I must tell you, Lordship. What's 85 to করে দিতে? Copy the.
Yes.
Milord, the first authority which I will cite, Milord, is reported in. Yes, reported in, Milord, 2023 SCC Online Calcutta 1945. Now copy that.
Great.
Paragraphs 20, 21, 22 and 23 for the proposition of suit for land. And paragraph 24, Milord, is apropos that query which your lordship raised under whether applicable of Order 7 Rule 10 to the original side. Paragraph 20, Milord, here, Milord, the reliefs have been subsequently set out. Here, Milord, they were asking for delivery of and cancellation of a document also, which was a conveyance. Now, applying this test to the fact of the instant case, it is apparent that the plaintiff seeks cancellation of a sale deed said to have been executed within the ordinary original jurisdiction of the court, and the defendants are also all within the jurisdiction. The plaintiff therefore says that the suit falls within the category of other suits which were adjudication of right title and interest is not required to grant relief's claim. However, to cancel a sale deed, the right, if any, created or extinguished by such deed will take place. The obvious conclusion will be that the same will lead to adjudication of title of an immovable property admittedly situate outside the territorial jurisdiction of this court. The cancellation of a sale deed will mean that the purchaser loses its title, if any, to the subject immovable property. At the same time, the title of the vendors in the said deed is required to be also adjudicated to find out as to whether the records had any valid right, title, or interest to the transfer. If the vendors have the title, they are entitled to transfer the same. Going by any way, the title of immovable property will fall for consideration, and without the same, the decree for cancellation of the document cannot be granted. Similar facts fail for consideration before the learned single judge of this court in Roshomoy Das, wherein it was held that the suit was a suit for land. I have no reasons to differ with the view. There has been no departure from these principles even after ADCON, as will appear from the more recent judgment of the Supreme Court in Excel Dealcom versus Asset Reconstruction Company of India Limited, reported in 2015, 8 SCC 219. The argument advanced by the plaintiff, relying upon Satyabroto বিশ্বাস that the sale deed itself executed in the teeth of the substituting order of injunction passed by NCC is void document, and no such right, title, or interest can be passed on to the purchaser, and a prayer for cancellation of the same does not transform the suit in hand into one as suit for land, is untenable at this stage. Even if the document is void, although courts, Miller, here also we have a prayer of declaration of cancel. Even if the document is void, although the courts have held this kind of documents and transactions to be voidable, a competent court has to declare the same to be void with an order for delivery upon cancellation. This is a point on the merits of the matter and does not clothe the court with territorial jurisdiction to receive, try, and determine the suit when the immovable property in connection with the sale deed has been executed is admittedly outside the jurisdiction. The moment a declaration as to cancellation of document, assuming without admitting the same to be void, is made, the issue as to the adjudication of title in respect of immovable property situated outside jurisdiction will come in the forefront, which will again make the suit one for land. The inevitable conclusion in the instant suit is that the same is a suit for land. As a consequence whereof this court has not territorial jurisdiction, it should be no territorial to receive, try, and determine the suit. This is Miller so far as the suit for land. The question now arises whether the plaint is to be rejected or returned to be being filed in the competent court of jurisdiction under the provisions of Order 7, Rule 11 of the CPC. The argument in this regard normally stems from the applicability of the provisions of Order 7, Rule 10 of CPC to a Chartered High Court in view of the provisions of Order 49 of the Court. Order 49 clearly eliminates the application of Order 7, Rule 10, that is, return of the plaint in respect of the Chartered High Court, like this court, and as such, it is often argued that the plaint has to be rejected and cannot be returned. In this context, I wish to refer to the notification referred to in 1997 to Calcutta Law Times, page 21, Yuko Wang versus Ratna Devi Jain. By the said notification, an amendment dated 14 May 1974 was published on the Calcutta Gazette in Part 1 on 1st August 1974 of the original site of this court. The provisions contained in Order 49, Rule Sub-Rule 3.1 were deleted, as a consequence whereof Order 7, Rule 10 CPC is applicable to this court. Similar, this is not, although not an issue, but since that fell for consideration. But this notification, Millard, is only found in that blue-colored CPC. Otherwise, in general CPCs, Millard, your lordship will not find this notification. Deleted. Order 7 deleted. Justice Same in the same lines, Millard. I'll not hold your lordship back much on these. Same lines your lordship will find to AIR 2011 Calcutta, page 148. Milchanagar. My lord, I'll only trouble your lordship with page 3 of the judgment. Rashomar. Having considered the submission at page 3, my lord.
Yes.
Having considered the submissions of the parties in CS such and such, seeks cancellation of the deed of conveyance dated 28 and for perpetual injunction restraining the referendum from exercising their rights. The deed of conveyance dated 28 May deeds with premises number such and such. By the said deed conveys the vendors who are possessed, seized and entitled to part sold their share to the properties. The purchaser by virtue of the said deed is possessed of the premises entitled to its enjoyment. Relief in such and such is declaration that the deed of conveyance dated such and such, defendant number 325 is null and void. Perpetual issue restrains the defendants either themselves or through their servants. In the event the relief is granted, the said would entail cancellation of deed of conveyance and therefore deprive the purchaser therein of possession and enjoyment of the premises. It will also amount to handing over possession of the premises as held in 82 Calcutta, where adjudication of title or possession is an issue, will render the suit to a suit for land. Then, my lord, by the second schedule, all right title interest the vendors have been transferred to the purchaser. Cancellation will deprive purchaser of the same, therefore question of the title will be issued. And cancellation will entail adjudication of title and possession. CS number says a suit for land and the court lacks jurisdiction. Test applied in 83 Calcutta also aids the petitioner and not the respondent. 83 Calcutta is one which I cited, my lord, to show that what is the primary. I will not multiply on this, my lord. It's basically the concept of section 16. If it's suit for land, my lord, then part of cause of action will not come into play. Automatically, my lord, it has to be at the place where the immovable property is situated.
Yes.
This, my lord, takes care of my first argument, which, my lord, your lordship will recall the learned judge did not deal at all. The second issue which the learned judge dealt with is the question of order 2 rule 2. Now, my lord, order 2 rule 2, my lord, I need not trouble your lordship again. The plaint before the second plaint money suit filed by my lord, my learned friend's clients before the Barashat court expressly says, and the learned judge records, that deceit on 16th of May has been recorded. And the learned judge says, very strangely, my lord, kindly take the order once, my lord. I think, my lord, the entire premise. Page. If your lordship has the memo that takes the impugned order, kindly, my lord, come to page 14, paragraph 17. I placed it, I'll just.
Yes.
As has been noted above, there are 3 suits between the parties. This is on order 2 rule 2. The plaintiff defendant number 1 and 2 have filed a suit for specific performance of the agreement. The plaintiff have filed a money suit. In order to consider the applicability of the provisions of order 2 rule 2 of the Civil Procedure Code, so far as the present suit is concerned, the cause of action in money suit 101 have to be taken into consideration, as the present suit has been filed by the plaintiff hearing. In money suit number 101 of 2015, although the plaintiffs have claimed that the defendant number 1 and 2 had acted deceitfully in relation to the agreement between the parties, the plaintiffs did not claim any relief with regard to the issue and allotment of shares of and in the defendant number 3, which in my respectful submission was available to him, which the learned judge probably also records that, but did not claim it. The defendant number 1 and 2 have not brought any, this is important, the defendant numbers 1 and 2 have not brought any material on record to substantiate that the plaintiffs were aware of the issue and allotment of shares of the defendant number 3 at the time of filing of money suit number 101. This is wrong on facts. The plaintiff in money suit number 101 has not only said that the acts of 16th May 2012 were deceitful, he has also gone on to say that the shares were transferred. What the learned judge probably missed is that the schedule A to that plaint is not mentioned in that paragraph. It is mentioned in a subsequent paragraph. That is what probably the learned judge missed. So what was troubling the learned judge is that the plaintiffs were not aware of the allotment of shares at even at the time of filing a money suit is probably incorrect on facts. If your lordship wants, Millard, I can show your lordship.
Give us the paragraphs of the earlier plaint which disclose that they were aware.
Yes.
Read about this. Just give us the paragraph.
Yes, I will. It would be paragraphs. It will start from paragraph 15, subparagraphs thereunder, particularly D, E, 16.
180.
No, I'm giving the paragraphs. In fact, in paragraph B, the learned judge probably did not notice it or issued share capital of such and such, authorized share capital less and paid up share of 500 to 28 companies introduced by the defendant number 2.
Placed it on the last occasion.
Yes. And this 28 companies, the reason 28 companies list
Given in schedule A.
is at page 192. Para 22. Kindly consider the last line of para 22. Query knowledge is there. So, Millard, this is an erroneous finding on facts. Now, therefore, Millard, if your lordship independently applies the test of order to rule 2, Millard, कौन printer? Kake. Oh, Millard, your lordship's desire was that the copy of the plaint with annexures should be filed.
The earlier plaint.
The first plaint. That annexure was not there. So,
Yes, we'll take it.
what you wanted the full copy. Now, Millard, it's no more, Millard, open to argument that what the plaintiff has claimed in the third suit, Millard, was open to him in the second suit. And Millard, if we now apply order to rule 2 independently, Millard, we will find that, Millard, your lordship has seen it, Millard, I'll just place it once. Every suit shall include the whole of the claim which the plaintiff is entitled to claim in respect of the cause of action. But the plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of this court. Then sub-rule 2, where the plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. And 3 also, will apply to my learned friend. A person entitled to more than one relief in respect of the same cause of action may sue for all or any of such reliefs. But if he omits, except with the leave of the court, to sue for all such reliefs, he shall not afterwards sue for any relief so claimed. Admittedly, order to rule to prate not. Now, the subsequent transfer of shares, which is also part of that, would also come, within a series of acts coming under an obligation to perform under that explanation or to order to rule 2 also. So, order to rule 2 in our respectful submission, will squarely apply to the facts of the case, and the test, has not been properly applied because of factual errors. Then comes the other part of it. So, these are the 2 points, so far as this appeal is concerned. Now, the next appeal, is also an appeal arising from the same order. But that appeal relates to the portion of the order, my lord, which, my lord, starts from paragraph 20 onwards. My lord, after having disposed of and dismissed our application, the learned judge says that the plaintiff claims with regard to the two agreements in the plaint in the present. This is all suo motu. There was no application. The agreements on the basis of which the plaintiffs have sued the defendants relate to the company incorporated on the provisions of the Companies Act 56, and it's relate to shareholding of the defendant number 3. The disputes can therefore be said to form a commercial dispute within the meaning of Commercial Disputes Act 2015. The suit has been valued in excess of the prevailing specified value. 2 other suits on the basis of the agreement in question in the suit have been transferred to the Commercial Code. In such circumstances, it would be appropriate to invoke the provisions of Section 15 of the Act of 2015 to the Commercial Division of the Honorable Court. It should be provision 15 of the Act to the Commercial Division for transfer. It should be something of that for transfer of the suit to the Commercial Court. CS shall transfer to the Commercial Division of this Honorable Court. The department shall take all requisite steps in this regard. The advocate on record will insert such and such. Now, Millard, when we preferred an appeal, this portion of the order was stayed. The transfer was stayed, so it's still a suit under the ordinary jurisdiction. Now, Millard, we had 2 points to argue on this issue, Millard. The first point is, Millard,
What is the other appeal number?
that would be 85. The very next appeal, Millard. What was the appeal? Millard, I'm not troubling the papers, Millard. This is the only.
All same papers. Yes.
Commercial court আমারটা পাতলা আনো না কেন তোমরা এত মোটা মোটা বই নিয়ে আসো না না হ্যাঁ তুই নিয়ে বসেছি
Yeah.
Millard, I have 3 points, Millard. The first point is, if it was a commercial dispute, the learned judge could not have dismissed my application in the original site. There's a purely, Millard, excellent. Now, having dismissed Millard, he could not have transferred it to the commercial division under 15(5). Because 15(5) is the only power that is given to the court for transfer. Other is all departmental job, Millard. 15(5) says, in the event that such suit or application is not transferred, which was the case over here, in the manner specified in subsection 1 or subsection 2 or subsection 3, the Commercial Appellate Division of the High Court may, on the application of any of the parties to the suit, withdraw the suit or application from the court before which it is pending and transfer the same for trial or disposal to the Commercial Division or Commercial Court, as the case may be, having territorial jurisdiction over the suit, and such order of transfer shall be final and binding. Millard, I have copies. I'm sorry, Millard, I should have handed up. I'm sorry, Millard, I should have handed up.
No, we have it.
Millard, 1 second, Millard, if I may please.
We'll catch up. Yes.
So, Millard, A, there was no application. B, the application had to be before the appellate division. And C, Millard, as I said, Millard, that the learned judge could not have disposed of my order, sir, could not have dismissed it or could not have entertained it if he had found that it was a commercial dispute. That's the second. Millard, the third thing is this, Millard, the learned judge says that it's a commercial dispute because it relates to shareholding of the defendant number 3. My lord, this probably is not a commercial dispute in my humble reading. Of course, my lord, subject to my lord, the Commercial Disputes Act 2, subsection 2C, my lord, shareholders agreement is 12. It doesn't say, it only says shareholders agreement. A shareholders agreement, my lord, as interpreted by Black and Oxford, is an agreement between the shareholder and the company. Here, my lord, we are looking at a tripartite agreement where, my lord, the shareholder and the company is transferring its shares to another person who is an outsider to the company. So it's a question of, my lord, a shareholders agreement is not there on record. My lord, this has been interpreted, my lord, by a single bench judgment of the Karnataka High Court, my lord.
This is a transfer to a third party.
Yes.
How can it be a shareholders
No,
agreement?
it is not. It is not.
The general concept of shareholders agreement is between the shareholders or shareholder and company,
Company.
or tripartite between
That
two
is what
shareholders
that
and
is what
company.
the Karnataka High Court has said.
But you can cite it.
No, he's only taken the two.
Shareholders agreement has a
Absolutely.
specific meaning. I mean,
That is what the judge has said, that this is the meaning of shareholders agreement and this is a sale and transfer of
but
shares.
is there any other provision which could hit you? I mean,
My lord, what can possibly partially hit me is
yes. So you address that also before Mr. Mitra argues.
no, my lord, what he is going to argue, I know. He is going to say that if it is a commercial dispute, then it is not an appealable order.
No, that is one of the points.
And that's the only thing.
After his exhaust his steam on that, we'll then come to the next point also. So because what could be it? I mean,
I don't think so, Miller. So far as this agreement concerned, Miller, let's take it for the timing. Even if it is a commercial dispute, then the order itself will go.
relating to immovable property used exclusively in trade and commerce.
Would be, would not be,
Is
but
it-
that has many. The agreement has nothing to do with that carrying on business. Agreement is
Does
only.
it relate to an immovable property which is used exclusively in trade or commerce? It's
But
a
as on
separate-
that date, the agreement says the building is under construction.
intention in the agreement was
Intention in
Yes.
the agreement was he wanted to run a hospital.
hospital.
Yes. But that intention probably has not even fructified today.
Or let me look into 7 also.
Seven.
Look at shareholding. Sure.
It is not.
Shareholding means agreement. Outlet transfer agreement is a third part. How agreement shareholder to the shareholder. It is share.
Is a third party. Karnataka.
No, but you cite the Karnataka judgment.
Yes, I will.
You don't know what will be coming from Mr. Mitra. Because there is the shares are being transferred.
Number of shares are there.
They may be
Yes. Shares are being transferred. But shareholders agreement presumes that the persons who are parties to the agreement are shareholders in a company. Or, Millard, they are entering into an agreement with a company where the rights and duties of the shareholders will be decided. But today, Millard, if I want to transfer my share to a third party who is outside the company, that may not, with respect, Millard, come within the definition of a shareholders agreement. Now, Millard, since the section or the definition clause is restricted, it says means. So, therefore, Millard, there is no scope for saying that they are open-ended, that it can include anything. So, we go by the definition and the interpretation which we generally apply, Millard. And now, Millard, kindly take the judgment which I have handed up to your Lordship, Millard, 2025 SCC Online Kerala, Karnataka, page 5. Millard, paragraph 7. is not in dispute. The petitioner defendant is a shareholder of Bangalore Fresh Fruits Private Limited. He wants to sell his shares to a third party. The respondent plaintiff agreed to purchase the same. For that purpose, they have entered into an agreement of 9th October 2020. The respondent plaintiff is not a shareholder of Bangalore Fresh. The suit is filed for recovery of money in respect of Annexure B, share purchase agreement. As per the law dictionary of shareholders agreement, a contract between a firm and the shareholders which outlines how internal affairs of the firm are managed, how any dispute are resolved, and what happens when a shareholder is bankrupt, resigns, is discharged, retires, or is
Very
in
beautifully distinguished. Share purchase agreement and share. This
Yes,
is a share
very,
purchase
very-
agreement.
This is exactly
Beautiful. Yes.
yes,
See,
absolutely. And that is exactly what you notice. That's why I didn't cite the
I don't
judgment.
know, but better cite it because we may have our doubts when passing the reserving judgment and passing the judgment, then we don't know it.
Yes. And Miller, the second thing is also same Miller. The second, it's Lexus Nexus.
Yes, yes, yes.
So Miller, so far as the second appeal is concerned, my 3 points are: one, the learned judge, if your lordship hold it's a commercial dispute, it was a commercial deed to start with.
The first part of the order should go.
The entirety of the order should go, and the matter can be remanded back with this decision to be taken afresh.
So 3 points on commercial dispute. One is that if it's a commercial dispute, the first part of the order should not be there. You should not have decided that. Secondly, 15.5 is applicable. Appellate division can do it. Did you also say that an application is required for
Yes,
that?
that is there in the section itself.
Yes.
It was done
yes,
so much.
that is the language. And the third one is what you are now citing. Shareholder. This is not a shareholder agreement. Regarding this is not an agreement relating to immovable property use exclusively. If they argue, then you answer.
Yes, because Miller, the point Miller at that point of time, Miller, the this building was coming up, and Miller, if your lordship wants to know today exactly, it is not being used for the hospital.
Yes, very good.
But that's beyond requirement.
That's clear.
Those who do this.
Thank you.
Let me I take your lordship.
Yes, Mr.
No. Well, the application on which the improved order was passed is an application under Order 7, Rule 11 for rejection of the plaint.
Right.
For rejection of the plaint, Miller, what I understand that on two heads. One is suit for land and the other one is Order 2, Rule 2. Just tell you briefly and then I'll take.
Yes, yes.
If it is suit for land, then two things has to be looked into. One is whether the court is called upon in the plaint to decide the title of the title with regard to the land, and whether the plaintiff has sought for delivery upon possession. Title and possession. If these two things are met, then you can classify it as a suit for land. Any other reliefs, I'll put it, even a specific performance is not a suit for land. A suit for specific performance is not a suit for land.
Justice Patheria distinguishes a previous judge.
I know. I'll cite a Supreme Court on this one.
That ground.
Yes.
That this is not a specific performance.
I'll tell you. Yes, Justice Patheria has said.
Justice
Yes,
Patheria
I have deeply
up to
obliged.
which it was placed by Mr. Dutt, the next paragraph.
Yes, the next paragraph.
We have
Because
seen that also.
in both the decisions of Justice Mukherjee's single bench and Justice Patheria, it was for cancellation of a registered deed of conveyance. The moment a cancellation takes place, it affects the title from A to B, or whether it's at all been cancelled, why it will be cancelled, fraud, many things can happen. Whether the vendor at all had the title to give the property. So the court will always have to go into the title of the land in both the decisions. Now today we are concerned with the suit for land. The issue is whether in the plaint court is called upon to say title and whether possession. These are two things that should be looked into. And then Order 2, Rule 2. In an Order 2, Rule 2 is obviously we have to look into the earlier plaint. 2. Now the first question, whether in Order 7, Rule 11, court can look into the plaint on which with Order 7, Rule 11 is comes and the annexures thereto. Whether the court can at this stage, in a Order 7, Rule 11's rejection of plaint stage, court can look into any other document, be that the earlier plaint.
The suit was mentioned, the filing of the suit was mentioned in this plaint.
The suit is mentioned. The suit is mentioned. Next, which has to be looked into, whether the parties are the same, whether the cause of action is the same. And the third is whether order to rule 2 can at all be, whether a plaint can be rejected in a stage of order 7 rule 11 as barred by law 11D on order to rule 2. Whether a plaint can be rejected at 11D as barred by law being barred by order to rule 2. So these are the broad things that has to be looked at. Today, Malat, keeping this in mind, I'll just first, because the plaint and other things already been placed.
So regarding your first point is that earlier suit plaint was not a part of this plaint. Suit was referred.
It's referred. I'll cite you.
It's a very weak argument.
I know, but why I'm making this, I'll try to make it the strongest reason is, in 2026, there is a Supreme Court on this point, specifically saying,
That makes it strongest. Always. Yes.
specifically saying that at the 7-11 stage, a plaint cannot be rejected at a 7-11 stage for order to rule. Drawing a distinction between these two. It can be at the end of the trial, whether I'm getting, that's different. I will not address that.
Even
But
if it's palpable from the plaint.
Not sure, I'll cite it. But it requires evidence. It's required evidence.
Can you see the judgment? Sir?
Yes.
We are now curious.
No, I'm কোথায় গেল রে ভাই? চাপ বাবা।
Very well.
No, this
With your own
judgment
claims.
is the best one.
We'll hold our curiosity for the time.
No, why not? এটা কপি জোগাড় করতে পারিস। বলে দিচ্ছি, কপি করে কাল রাত্রিরে বের করে বলে দিচ্ছি। 2026 SCC online SC 603.
Just half a minute.
26 SCC online SC 603. ছজন প্রশ্ন I'll take this question. Yeah. এটা বলছি সবকিছু জানেন ঠিক আছে yes Malad, in this judgment, Malad, identically two suits were filed.
Right.
One by the original owner. On the death of the original owner, his legal heirs filed a suit for cancellation of instrument. After recording the facts, Lordship 4.1 on the law which is being discussed. 4.1.
Right.
In the instant case, an application was filed under Order 7, Rule 11D of the court on the ground of rejection of the plaint. And the suit appears from the statement in the plaint to be barred by law, any law. In this regard, various decisions of this court with regard to rejection of the plaint under Order 7, Rule 11 of the court could be discussed. Then the judgments which we regularly cite are quoted. All are quoted, Malad. Yes. Then, Malad, the next page, Order to Rule 2. After quoting all the decisions,
Yes,
Order
yes,
to Rule 2 is quoted. I'm not placing. Now, Malad, 5.1. Order 2 of the court deals with frame of the suit. Order 2 Rule 1 states that every suit shall, as far as practicable, be framed so as to afford ground for final decision upon the subjects in dispute and to prevent further litigation concerning them. Thus, the fundamental aim of Order 2 Rule 1 is to avoid multiple suits which may be founded on the same cause of action or may be relating to the same subject matter. Similarly, Order 2 Rule 2 of the court elaborates the objective of Order 2 Rule 1, whereby, by stating that the suit to include the whole claim and deals with consequences of relinquishment of a part of the claim and omission to sue for one of the several reliefs. The object of order to rule 2 is to avoid multiplicity suits. This is because the litigant who does not include all grounds available to him on the subject in dispute in one suit and institutes several suits against the same parties on the same subject in dispute would abuse the process of court. The difference between order to rule 1 and order to rule 2 of the code is that in order to rule 1, the phrase used is subjects in dispute, whereas in order to rule 2, the phrase used is cause of action. Secondly, order to rule 2 provides that failure of a plaintiff to abide by the mandate of the said rule results in the plaintiff being debarred from instituting a fresh suit for that claim. However, Rule 1 does not provide for the consequences that will result for non-compliance, except possibly under Order 7, Rule 1A. Thus, under Order to Rule 2, the bar is with regard to the right to sue in the context of relinquishment of a part of the claim and omission to sue for one of the several reliefs.
Yes, we'll brush our memory
Yes, yes,
judgment.
yes, that is it. Order to Rule 1 term of portion. Every suit shall be framed. Subject in dispute. Then order to rule 2 is
Yes.
where a person is entitled to more than one relief in respect of the same cause of action. He may sue for all the reliefs, or he may sue for one or more of them and reserve his right with the leave of the court to sue for the rest. Now, just pausing here for a moment, I must also indicate in my suit before Barasat court, my lord, I had prayed for order to rule 2.
Achha, that suit is still pending.
Yes. The Barasat is not transferred to Rajarat, but it is pending. But there's a specific relief prayed for order to rule 2. It's there. In the plaint, Lordship can press 2. It is page 196. Page 196, the reliefs are for order to rule 2. Generally, we treat it as.
He was not granted.
Now I'll tell you, Lordship.
No, there may be a
Different.
there will be an argument on that.
I will address this. But I have checked up personally, I have called up my friends. In the lower judiciary, I know Lordship may be knowing, I have never come across of any the first order or the second order which says court fees paid correct, the standard usual orders in the first. I have never come across any order by saying that whether order 1 rule 8 leave, order 2 rule 8 leave is granted. Unlike in High Court, what we do, we present the plaint before the Honorable Judge because it cannot be filed before the master. It is not done. It is, if it is leave is prayed for, it's deemed that the leave is there.
Apart from an application has been filed.
No, I know. I'll tell you.
Separate application was
No, I'll tell you. This issue was raised subsequently. This issue was raised by Justice Shomenchen once. That this leave was not expressly granted. This leave was not expressly granted, though prayer is made. This issue came up before this court. Then we went back to the court and had filed an application. We paid for this application. We said that though the prayer was made, expressly that liberty was not granted, kindly grant me that liberty. That application copy order to the this order was this order touch. Now the order.
This is in the paper book.
No. Copy did that, Mama.
Yes.
Now, when this issue cropped up, but any event, I'll stick to my first point that once you make a prayer, this is not the system. Even I checked the civil rules and order.
Why does it say that 711?
No, that I'll just to.
You are.
Yes, just to deviate from that. I have prayed. I have prayed before the court below. Yes, there is no express order. I must also say, but that's the system of the. I won't show the system, but that's what happens. There is no order to rule to leave. But once this issue came up,
We
we
cannot
went
take
back.
note of what happens in the district courts unless it's a custom or usage which has acquired the force of law.
Yes,
Cannot take that. That is
I
not a
know, I know,
practice.
I know. But generally, I have not
Practices
seen.
differ from court to court.
But I have not, Lordship, is not that the order number 1, order number 2.
You have not come across, and I don't remember having coming across. So I
Both is
might
to
have
my
come across.
both is to my favor.
No, yes, but I can't remember means it's
Whether you have come across.
might have come across, but I don't remember. That may also happen. That possibility is there. So if you say you have not come across, we proceed on that.
Yes, I'm saying I have not come across. Even I tried to inquire with my colleagues, my lord. Says when you pray for a leave, it is there in the plaint. Is there in the plaint. Order 1, the order number 1 does not say order to rule to leave has been granted. Now we went back to the court and prayed for a leave because of this issue came up before Justice Homan shed this issue. On this, the order was passed, my lord. That application, plaintiff files an application order 21. We're praying for stay of today is fixed for hearing. The hearing is 8 পরে কিছু হলো না. Now we have filed an application. These 2 orders were hearing is taken up for hearing, both the parties. That was. Oh, then it was fixed for hearing this application. Then the order was passed for liberty be given to file written statement. This happened. I should say this happened. This is then the order did not record anything. Now, my lord, the leave was prayed for first. Now we come back to the judgment of this.
Yes.
I was placing 5.4. It is for the defendant who raises the plea of bar under order to rule 2 of the court to establish that the subsequent suit was in respect of the same cause of action on which the earlier suit was based. In respect of such cause of action, the plaintiff was entitled to more than one relief, and without the leave, he had omitted to claim such a relief in the earlier suit claimed by him thereafter in the subsequent suit. However, if the right to relief in respect of which a further suit is brought did not exist at the time of institution of the former suit, the subsequent suit is not barred, held by Allahabad. While filing the first suit, if the plaintiff reserves his right with the leave of the court to sue for the rest of the reliefs, then he can file a second suit for the remaining reliefs. On the other hand, if no such leave is obtained, he will be precluded from afterwards suing for any of the reliefs omitted. Certain judgments have been referred to in the context of rejection of the plaint. Now, order to rule 2, 5.6. Order to rule 2 of the court deals with the relief sought in a suit by the plaintiff in respect of a cause of action. Order to rule 2, 1. Therefore, states that every suit shall include whole of the claim which the plaintiff is entitled to make in respect of the cause of action. But the plaintiff may relinquish a portion of his claim in order to bring the suit within the jurisdiction of any court. Order to rule 2, subrule 2 of the court states that where a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he has not afterwards sues in respect of the portion so omitted or relinquished. Order to rule 2, subrule 3 of
This is a paraphrasing of the provision.
paraphrasing of the provision. Yes. Then 5.7.
Let us come to
the portion.
relevant. Same cause of action. It has to be same cause of action. Para 5.8.
Yes, a paraphrase. Yes, man. Now,
subsequent cause
yes,
of
man.
action.
I'll skip this. Now, then 5.9. Then,
Yes.
and then is yes. I just
If it's a distinct or subsequent cause of action, no order to rule.
No.
Accept
the test of determining whether order to rule 2 of the court would apply to a particular case is whether the relief sought in the second suit or the subsequent suit in fact founded on the cause of action distinct from that which was the foundation of the former suit. That is the paraphrasing. Now if we go on, my lord, then it recorded 5.12. It cites another Supreme Court of Justice Pardiwala.
Yes.
5.12, paragraph 47 is quoted. Mainly the cause of action, Roman 4. Similarly, several tests have been laid out to determine the applicable order to rule 2 of the court. While it is acknowledged that the same heavily depends on the particular facts and circumstances of each case, it can be said that a correct and reliable test is to determine whether the claim in the new suit is in fact founded on the cause of action distinct from that which is the foundation of the former suit. Accordingly, if the evidence required in support of the claims is different, then the causes of action can also be considered to be different. Furthermore, it is necessary for the causes of action two suits to be identical in substance and not merely technically identical. This is Roman 4. Roman 5, the defendant to take shelter under the bar imposed on order to rule 2 must establish A, the second suit was in respect of the same cause of action as that on which the previous suit was based. B, in respect of the cause of action, the plaintiff is entitled for more than one relief. C, being thus entitled to more than one relief, the plaintiff, without any leave of the court, obtained from the court, omitted to sue for the reliefs claimed. 5, 6, the defendant must also have to produce the earlier plaint in evidence in order to establish that there is an identity of causes of action between the two suits and that there was a deliberate relinquishment of a larger relief on the part of the plaintiff. Since the plea is a technical bar, it has to be established satisfactorily and cannot be presumed merely on the basis of inferential reasoning. Number of the findings of in this 5.3. Bar to sue is distinct from a suit being barred by any law.
What?
5.13.
Bar to sue is distinct from a suit being barred by any law. Achha. Learn
In the
everything.
former, a suit cannot be commenced at all and therefore would have to be dismissed on an application of order to rule 2 of the court, while in the latter case, the suit can be commenced but is not dismissed after recording evidence, depending on the facts and circumstances of the case and on the analysis of the cause of action in the former suit and the subsequent suit. In the case of rejection of a plaint, recording of evidence on the bar of a suit may not be necessary in all circumstances, or it all depends on the nature of the bar.
In case of rejection of a plaint, recording of evidence on the bar to file a suit may not be necessary in all circumstances. Yes. It cannot be necessary. If
It is
it's
not
necessary,
necessary.
then it cannot be a case for rejection of plaint.
Yes. So I say, my lord, here in my case,
Now, in the case of rejection of a plaint,
in a
recording
case
of evidence
rejection
on the bar to file a suit may not be necessary in all circumstances. It is not necessary in any circumstance. If you take evidence, then it cannot be order 7 rule 11.
cannot be order 7.
Would have been at best order 14 rule 2.
Then is this.
Please elucidate the
My
matter.
lord, I'll read.
We want an elucidation on this proposition. Since you are citing, you have to own up to this.
Owning up.
Give us
this-
one example where evidence is taken, but it's
My lord, I'll tell you that it's like
order 7 rule 11.
Limita-
One example. It's rejected at the threshold, but evidence is taken under 711.
no, can't be. How can I sell in both the boats? If it is rejected in the 7-11 stage, then it won't
That's
go to
what
the
I said.
evidence
Order
stage.
14 rule 2, you can
That
understand.
is different.
Still understand.
That is.
But
But
also there's some.
But preliminary issues and other things.
So where is your proposition? Please come to the proposition. We
The
can't.
proposition is evidence has to be
These are
taken.
paraphrasing of this.
The evidence has to be taken, my lord. Then for 5
No,
point.
you said that order to rule 2 bar cannot be a bar under order 7 rule 11.
Yes, that's the last is 5.20 after deciding everything. But if I just straight away, if I can read 5.20 and 5.21,
Absolutely.
there's only these two paragraphs. As opposed to the above, under order to rule 2 of the court, the right to sue is taken away in terms of sub rule 2 and 3 thereof, which means the suit could not have been filed at all. On the other hand, under order 7 rule 11d, there is no bar to sue, but the suit is barred by law from being filed. This is a subtle but distinct difference between the two. If the conditions between the order sub rule 2 and sub rule 3 of the order to rule 2 of the court are satisfied in a case, it would be a case of being curtailment of the right to sue for the claims relinquishment omitted in the earlier suit. It is not a case where the plaint has to be rejected as it is barred by the provisions of order to rule 2. In other words, application of order to rule 2 of the court in a case can result in rejection of relief being granted to the plaintiff, which may, in certain cases, also result in dismissal of suit itself. But thus does not result in rejection of the plaint under Order 7 Rule 11D of the court. We think that in a case where Order 2 Rule 2 of the court applies, there is no legal bar to file a suit, but the relief sought for or the claims made therein.
If the
cannot-
reliefs cannot be granted, the reliefs are rejected.
But that is evidence. That paragraph 21
Then
end.
what else does the plaint do? I mean, if you don't grant relief, what else do we grant in a plaint?
That is after evidence. That's what I think
Your
is,
thought will not do.
no, that's what is recorded. 5.21. 5.21. We think that in a case where Order 2 Rule 2 of the court applies, there is no legal bar in filing a suit.
A thought is based on the previous sentence.
The
In other
previous.
words, the application of Order 2 Rule 2 of the court to a case can result in rejection of reliefs being granted to a plaintiff. So we
That is
can
the
reject.
final, the reliefs at the
Case
final
of it,
stage.
we can reject the reliefs, but we can't reject the plaint.
That
So we'll keep the rest of the plaint and we are rejecting the reliefs.
no,
We reject the reliefs and keep
Then-
the body of the plaint. We say,
without the relief, the
So you-
plaint remains in the books.
put that up in a plaster of Paris and hang it up on your wall. We'll just reject the reliefs.
Now I'll
We
just
can
come
do
to,
it right now.
now I'll come to that
It can
also.
be done.
I'll come to that also. Beyond this judgment also, my lord, I'll try to satisfy.
Seriously. Yes. No, this is personal.
Come to me. It come to me.
Yes.
Now, my lord, on the other hand, in a case of Order 7 Rule 11D, if there is express or implied bar for filing a suit, when any law then, on the meaningful reading of the plaint, it has to be rejected. The suit need not be proceed on to record evidence on merit, but only to the extent where evidence is necessary to be recorded for the purpose of rejection of the plaint, such as on the ground that the suit is hit by the laws of limitation or on the principles of res judicata. Thus, the bar created by any law to filing of a suit is different from a plaintiff suing for certain claims or reliefs, which could have claimed a suit having regard to Order 2 Rule 2 of the court. Therefore, in our view, the application of Order 2 Rule 2 cannot be construed to be a ground for rejection of a plaint and Order 7 Rule 11D. Now, then, my lord, paragraph 7, just 3 lines in paragraph 7.
Yes.
A juxtaposition of the above discussion with the discussion for rejection of a plaint under Order 7 Rule 11D must be made on a conjoint reading of Order 2 Rule 2 with Order 7 Rule 11 of the court. It emerges that the plea under Order 2 Rule 2 of the court cannot be a basis or a ground for rejection of a plaint. On the other words, if the defendant, it is for the defendant to establish by way of evidence the bar of the subsequent suit under Order 2 Rule 2 of the court filed by the very same plaintiff. In such an event, on a comparative analysis of the plaint filed in the first suit and the plaint filed second suit, if the court comes to a conclusion, the second suit was filed on an identical cause of action, which leads to filing of the first suit, there was an omission to me. So it has to be.
We file a suit for declaration of our title and permanent injunction.
But
In
Lordship,
the first paragraph, we say we have previously filed a suit for declaration of our title and injunction in respect to the sales and property. We'll have to wait for the evidence to be laid by the defendant. You are citing this judgment, and since you have cited, we have to now do whatever we have to do.
no, my lord, this is.
You are the culprit.
No, I'm not the culprit.
So
I can't say anything. I can't say anything more.
We have given you a test case applying this principle.
No,
You say, what should we do?
This is, my lord, in around 2 months back, this decision.
Yes, even
No,
yesterday's judgments are
yesterday's-
binding on us.
No,
Tomorrow's judgment
my lord,
are luckily not binding on us.
nowadays, my lord, the life law is there.
Tomorrow's judgments were also binding that we had to anticipate it. We can anticipate and we can
Jyotishi. Now, my lord,
bind ourselves by
this
tomorrow's
is
judgment.
now a live law that this comes. We have a
Live law,
substitution.
live stream,
Live law,
whatever.
there's practically every
Details of
day,
court won't change by live law.
every day of.
Yes.
But so this is now.
We have to now deal with this. Yes.
1 minute.
We have to deal with this now since you have cited. Yes. No, but it's there. Definitely, you have a right to say.
It's there. Now coming back, so this is under Order 2 Rule 2.
Yes.
So I say under Order 2 Rule 2, a plaint cannot be rejected in the threshold under Order 2 Rule 2. First is whether the court will look into a different plaint, whether what is the evidence will be led in a different suit, what are evidence will be led in this suit. This has to be gone into, cannot be at this stage. Second, I will not give up that the reliefs has been claimed. Order to rule to relief is there in the prayer C.
Yes, you have made a prayer.
Prayer
You have made
C
an
is there. Prayer C is there.
C in the plaint as well as a separate application.
Yes. Is a plaint as well as separate application. But the separate application, I must say, is not with the records, but a certified copy I can hand over.
But in the plaint also you say.
Yes, it's in the plaint. That page in the plaint 196.
190.
The specific
you have
prayer.
given the page.
Yes, the specific plaint relief is there. Now, the custom which I said, I will not repeat that custom. Now, I go back now. The next point is suit for land.
This custom is prevalent in the original side of our code.
No. In the original side, my lord.
This is an original side order.
No. Order to rule to leave is sought in the
In that,
Barasat.
right.
It is sought in the Barasat.
Right. Yes.
In the trial.
before-
In the Barasat. Sorry.
Right.
Here we have to go to the learned judge, was honorable judge, to seek a leave.
No, not.
Yeah, but- Now, this is my answer to order to rule. Now we come back to suit for land. Now the question that begs an answer, whether in the suit in the Calcutta High Court, whether the court is called upon to decide title of the land and whether I have sought for possession. Now, the agreement in question, I will take you to the agreement. Now, let's see the agreement. The first agreement I have called upon, there are two agreements to be delivered and cancelled.
Agreements repeatedly say, which Mr. Datta has placed, that includes, the understanding is that it includes the right in the property
Yes.
asset.
I'll just say.
Repeatedly said, that is you take the bull by the horn.
I take the bull by the horn. I'll say
Yes.
this agreement, this undisputed that the land belongs to the company.
Hmm.
Number one. There is no agreement to transfer the land. There is no agreement by the company to deal with the land. There is no agreement to decide the title of the land. So, and the land is an asset of the company. It is settled law from 1954.
Bacha Gazda.
I'm carrying that also, Mala, that shareholders' right is with regard to the shares.
We are anticipating this argument actually. Bacha Gazda has to be argued here for you.
I've carried.
Sorry, yes.
So, is shareholders' right is with the shares, and in a private limited company, if at all the profits, the debentures or the profits are distributed, whatever. In a limited company, you can get your shares will go up, your value in the
Whatever could be
share.
the effect, maybe the effect of that transfer of shares, they could not have transferred the
It is-
assets of the company.
It is not, could not. There is no agreement to do that.
Hmm.
I'll place the agreement. Agreement is a shareholders' agreement.
Understanding and includes and their perception was a perception.
A perception.
Or an effect at best.
Well, then I will cite one decision, a division bench of this court, where a land, a cold storage situated in Hooghly district was in issue. Now, the shareholders were selling their shares. It was held is not a suit for land. Because the land belongs to the company. The company is not selling the land. Now, keeping this in mind, we come to the agreement. The agreement is, I am the 95% owners of the shares of the company. Today, for whatever reason, I thought I will sell my shareholding to Mr. Dotto's client. So I am the transferor. He is the transferee. That's exactly what is written in the agreement. The company is a party. I will say the company is not required to be made a party. Because 95% shareholding is going, whether the only asset of the company is the land or the company is having 20 assets, is not for consideration. The title is not in dispute. Now, if we keeping this in mind, we come to the agreement once. 111.
Half Nelson. Half Nelson. Yes.
Now here, 111.
Yes.
Who are the transferors? Dilip Ghosh, Kamala.
Shareholders.
Sure. Venkatesh Medicare is the owner of the land. He is nothing. He is only the second party. He is only the company and the second party.
They were confirming parties.
They have
They
signed.
signed.
They have signed. Even if it is the company, the confirming party. But whether the court is called upon to decide the title, or whether the title or the ownership of the land is getting changed. Now, 112, fun idea. Fun idea is the transferee company. The fun idea is the transferee. Then the transferors and the company jointly and severally declares, this is the declaration made.
So if the company jointly and severally held,
Yes, can be. But the question is whether the title has to be decided and what is being transferred under the Transfer of Property Act.
but the company, you said company has no agreement, but this is
The company is a confirming party. Company is agreeing to this share transfer. Is the company agreeing to transfer the land? Or the title of the land is getting transferred? That has to be gone into. Now we'll read. B. Dilip Ghosh and Kamala Ghosh, the transferors herein, and the directors of the company are in full control and management, including the assets.
this does not mean anything. But
Does not mean anything. Now, if you turn over the now you say the the company is the lessee of all that leasehold interest in Vidhanagar Salt Lake. It is not Dilip Ghosh who is the owner. It is the company who is the owner.
Yes, yes.
Then, my lord, if you turn over 2-3 pages, my lord, now which means the appellant has placed 114, the last 2 lines B. The transferor have agreed to sell entirety of the shares. So what is being transferred? Transferor is Mr. and Mrs. Ghosh.
Yes.
Relying on the aforesaid representations and assurance, I'll tell you why the company was made. I'll just place and then. And declarations of the transferors and the company believing the same to be true and correct and acting thereof in good faith and having total control and management of the company with all its assets. Next, now this agreement witnesses. Sale and transfer. The transferors have jointly and severally agreed to sell and transfer the entirety of the said shares being 45,000 fully paid up equity shares of ₹10 in the capital of Venkatesh Medicare. The company and the transfer, relying on the aforesaid representations and assurance made by the transferor and the company mentioned therein, believing the same to be true and correct and acting in good faith, have agreed to purchase and acquire the said shares and all right, title and interest, whatever the transferors and their respective rights and interest. So the transferors have an interest in the shares. The transferors cannot have an interest on the asset of the company. That was Bachagas. Absolutely and free all pledges and encumbrances. And I'll just, this Lordship sees the word recon is there. I'll just say what is recon. I'll come back.
Yes.
Liabilities, including loan liabilities. Now here the loan, that is the reason the company has taken loan and my shares were placed with this recon. So that is the reason the company was roped in, because the new purchaser was supposed to pay me and I was supposed to pay it to recon to get my shares released and then the shares will transfer. So that is the reason the company comes in, because the loan is with recon. Normal. D. It is agreed and understood and clarified that purchase and acquisition of the said shares has been agreed by the transferee with the intent and object of having total control, management and acquisition of the company along with his assets. So intent is to take over the company, whatever the company is having. It is, I'll say, it is exactly a share transfer agreement. One set of shareholders agreed to transfer, if it is 95% or it is 10% or whatever, or 51%. The shares from one group A goes to group B. That's exactly what is happening. Now, if we turn over the consideration, the company will not get a single penny. If the company is called upon to transfer the land, the money will have to be paid to the company. Today, the consideration is being paid to me. Then how can the company will sell the land or title to the land? Then Transfer of Property Act, transfer of title has to come. Now, consideration. Total consideration for sale and transfer of entirety of the aforesaid subscribed and fully paid up for 45,000 have been mutually agreed as 21 crores as a total consideration amount, taking into consideration the all valuables of the assets. So how you value it? So this entire money now, the total consideration shall be paid by the transferee in the following manner. 20 lakhs to the transferors as earnest money as part of consideration before the execution.
These are not relevant for
No, that's why I'm placing who will get this 21 crores.
He will get.
I will get.
You are the transfer.
I will.
You described as a transfer.
So the
Because you have been distinguished, you and the company in the first clause, saying that transfers and the company. So therefore, you are not the.
So
company is not
the land is not getting transferred. Company is not getting a single money.
You will get the consideration.
I'll get.
You are transferring your shares.
So this is the agreement which happened.
Not such a difficult argument to understand.
Now, my lord, now is Mr. Dotto in the other side. Now very.
But let him make it difficult.
Mr. Dotto and then sorry.
He's not capable of making it very difficult.
Ore babare. Ore babare. Mr. Dotto, Mr. Samrat Sen, I fear them a lot.
He's not
And then
persons.
And then
commenting on concepts.
No, and then item 1
is also concept.
Then item 1 in code 16. Then, my lord, the next agreement, which is page 135. So this is the first agreement.
Yes.
I won't take you through the other terms and conditions because they are not important. Now 135. 135, the company is not a party. It is Dilip Ghosh, Kamala Ghosh, the plaintiff. And next is Fun Idea. The page 136, the second para.
Yes.
It is mutually agreed by Dilip Ghosh and Kamala Ghosh and Fun Idea, represented by director such and such, that all the terms and conditions of the agreement of the 16th May 2012, which is the first one, will supersede by the following terms and conditions. Then these terms, the value got reduced. Now, my lord, why it got reduced, to how much it got reduced may not be germane or important today at this stage. So it got reduced. A different mode of payment was given. The reason, once again, if I may say, because by the time the purchaser agreed that I will pay to recon directly. So that is because now she will kindly come to page 137. The third, this is not clear, but the second party is the purchaser, has agreed to clear all legal dues to Allahabad Bank. Allahabad Bank is now recon because under the Allahabad Bank term loan of the company taken for consider building and to clear the lien charges and then file a form 70. So some payment will go to him. So what I say here is agreed to clear the liabilities. Now, so what I say, these two agreements of which I seek delivery upon cancellation on the ground of fraud, whatever ground, cannot be construed to be a suit for land. Keeping these agreements in mind, Lash will kindly come to the reliefs I have claimed in the suit here, which is the High Court suit, which is at page 4. Now here I have made Allahabad Bank and all other transferees a party. In the Barasat suit, those 28 companies were not parties. Sorry, rather are not parties. So the parties are not the same. Here the cost title runs up to 37 defendants, which includes the new 28 companies to whom the shares has further been transferred. Now, the reliefs. I'll take you straight to the reliefs which I put. Page 46. Clause 12. Declaration that the agreement of 16th May 2012 and the 11th April 2013 stand vitiated by fraud and the same be adjudged void, delivered upon cancelled. A declaration that the issuance of unallotted shares, in defendant number 3, the defendant number 3 is the company. in favor of defendant number 6 as Schedule A is vitiated by fraud, delivery upon cancel. It shares. Declaration the transfer of 26,000 shares of the plaintiffs in favor of D1 and D2 is fraud. Injunction restraining defendant number 1, 2 and 6 to 33 holding themselves as shareholders. Injunction. Injunction restraining D1, D2 and 36 from exercising any right as shareholders of D3. Perpetual injunction restraining 37 to 34 to 37 from holding themselves as directors. Perpetual injunction from releasing the title deeds of D5. Against D5, release the title deed in favor of D1 and D2. Decree for damages of 50 crores. Alternative. Now here, the court is not called upon to decide the title. The title is not in issue. The title is not in dispute rather. And no reliefs claimed for possession. It is a shareholders agreement, one group transferring shares. Now, what is a suit for land? What exactly, what is the judgment? So she will give me a minute. Add con. Act extra আছে। আচ্ছা এটার একটা এক্সট্রা আছে। অ্যাড con আচ্ছা আপনার কাছে আপনার কাছে আমি ওই জন্যই সাইড করেন। This is from Bombay, but I've checked the clause 12 is identical.
Yes,
Is
yes,
identical.
yes.
Now,
Clause
let's
12.
kindly straight away come to paragraph 13. It recorded the five bench of Supreme Court. It's Bombay and Calcutta is 30. It also records the Holkar jurisdiction, paragraph 13. In Mulji Jatia Company, there is a divergent opinion among the learned judges of the 5 bench of the federal court with regard to the import of the expression suit for land. Chief Justice Kania opined, taking the suit as a whole, one has to consider whether it is for the purpose of obtaining a direction for possession or a decision on title to the land, or the object of the suit is something different but involves the consideration of the question of title to the land indirectly. Justice Faisal Ali. If I had already, I felt necessary that I was called upon to decide it, I would have agreed with the line of cases in which it has been held broadly. Speaking with the expression suit for land covers the following 3 classes. Suit for determination of title to the land.
The third one may be relevant only. Other suits in which the reliefs claimed, if granted, would directly affect
Affect title and the possession to the land.
At best, that could be applicable.
At best,
It is not
the
suit
best.
for declaration of title.
So reliefs granted would affect title.
Directly affect title and
Directly affect title. That at best. Then Justice Shastri, recovery of possession and control of land are apt to connote a suit primarily for seek an adjudication and title of the property or determination of a right or interest therein. Justice Mahajan, in an attempt, I therefore confine myself. The nature of the suit is in substance involves a controversy about land or immovable property, and the court is called upon to decide conflicting claims to such property, and a decree or order is prayed for which will bring about a change in title to it, that a suit can be said to be in respect of immovable property. But where incidentally in a suit the main purpose of which is primary object of which is quite different, some relief has to be given about land, the title to it not being in dispute in real sense of the term, then such a suit cannot fall within the 4 corners of this expression. Then it records will kindly now of this court paragraph 15. From the above discussion, it follows that a suit for land is a suit in which the relief claim relates to title to or delivery of possession of land, title to or delivery upon possession of land or immovable property. Whether a suit is a suit for land or not has to be determined on the averments in the plaint with reference to the reliefs claimed therein. Where the relief relates to adjudication of title to land or immovable property or delivery of possession of land or immovable property, it will be a suit for land. We are in respectful agreement with the expression of Justice Mahajan. Justice Mahajan is the last one which was recorded. Justice Mahajan.
Yes.
Then in paragraph 16 is a suit for specific performance. So it says in a suit for specific performance is also not a suit for land, because the title of the vendor is not in dispute. Court is not called up and decide title of the vendor. And in a suit for specific performance, unless you pray for possession, the court will not give you possession. So in a simplicity, a suit for specific will not come. So this is what is a suit for land. But this judgment has next been a division bench of this court, my lord, 2021 SCC Online Calcutta 2688, which is in CHN. This is a 2011 4 CHN 362. This is the division bench of this court.
Yes.
Yes, my lord.
Yes.
Now, my lord, this the second page is no paragraph numbers. There's not the system of paragraph numbers there.
No.
Now, the second page, if you see, what are
Yes.
the reliefs claimed?
Yes.
Is identical to my case. The reliefs claimed in the plaint, out of 7 plaintiffs, plaintiff number 1 to 6 are shareholders of plaintiff number 7, is a private limited company, 7, provisions of the office at Strand Road. Prayers, decree declaring that the plaintiff number 1 and 6 and the defendant number 7 to 15 constitute 100% shareholdings of defendant number 7. Decree declaring that the defendant 1 and 6 are neither shareholders nor directors of plaintiff 7. Perpetual injunction restraining the defendants from managing any asset, including its cold storage and properties of defendant number 7. Now, this cold storage was in Hooghly. This cold storage was in Hooghly. Now, on these reliefs, now the existing group was transferring shares. Now this. Now, if Lordship turns over to the page 8, that we get the page number in the top here. Page 8 in the below that SCC version, then page 8.
You can come to page 14 directly. Right?
Yes. Now, there was also a memorandum. There was also a memorandum between the parties to share transfer. Here in this case also. Page 8. Under the memorandum, the group A was obliged to transfer to group B. The same memorandum happened.
Already.
We'll take over the liabilities.
No.
Okay. Then, Malad. Yes, page 14. Page 14. After Mr. Mitra's and Mr. Shah's submissions are recorded, Malad, ATCON is cited after hearing. After hearing the counsel for the parties and after going through the aforesaid
Dispute regarding control and management of the company. Therefore, not a
suit for land, though the asset was in.
And ATCON was referred to.
ATCON was referred to. Though exactly the same in my line, the cold storage was in Hooghly district. So here it says it is not a suit for land, because only the shares getting transferred, the management of the company can get transferred. Does not mean the asset of the company is being dealt with. That's the only thing. It does not mean the assets of the company.
Come back and.
Well, পরিশ্রমকে দেখানো হয়ে গেছে।
Implementation হবে।
পরিশ্রম না না জজ নিজেই করে নিয়েছো, গলায় দিয়ে পড়ে নিয়েছে, ইচ্ছা করে দিয়েছি তো এটা।
Mr. Mitra says that he will take time till recess, my lord. He
You
will
will ensure that it doesn't.
No, no, I will not take only thing, my lord. So far that commercial court, the commercial conversion to commercial, that issue is concerned, my lord.
That you have some difficulty to reply today. Say that. We'll consider that. I mean, consider that means if he finishes, then we may keep it on some other day for it.
Yes, for reply.
For reply.
But for me also, but with regard to the commercial court.
Oh, he
No,
will
no,
not
why?
conclude today.
ঠিক আছে।
You conclude today.
No, no, only that Kerala judgment I just see. I'll conclude.
First of all, it's not a Kerala judgment.
It's a
Karnataka.
All the states of South India are not the same,
Not the same.
as opposed to what
Karnataka.
typical North Indian people think. And-
If anything doubt.
And you have to. That judgment is very succinct, very very short.
Shareholders agreement.
Difficulty is
You
whenever
explain to us that shareholders agreement is something else than held by the Karnataka High Court. Will accept that.
difficulty is whenever he thinks of South India, my lord, he only thinks of backwaters.
But pardon? He?
Whenever he thinks of South India, he only thinks of backwaters, the most expensive place in South India.
না, তুই চলে যা। না, ঠিক। না, my lord,
South India. Southern part of it. Yes.
now the next decision is, which was that the shareholders are not the owners.
Yes.
Yeah, that's the formally, আমার কপিটা কোথায়? আমার কপি ঠিক আছে, সেটা আমার কপিটা বের করো। বাচ্চা এফ গজদার। আমার কপিটা কোথায়? Yes. And here, my lord, it is paragraph 9, 10, and 11.
It's very satisfying to utter the name of this judgment without sounding abusive.
Gazdaar.
Therefore, people always refer to it by name. And I found that. It's very satisfying. We are satisfying, particularly after being confronted with so many propositions which I just now cited to Mr. Mukherjee and all. Yes. So what was held in this
Here,
judgment? Mr. Mukherjee?
paragraph 9.
This is good.
Yes.
This is good. It's good now, my lord. Still held the fort place.
The board, my lord, that
Very
there is one line over here in paragraph 11. After 5-6 lines from the top, there is nothing. There is nothing. Paragraph nothing
in
in Indian law to warrant the assumption that a shareholder who buys shares or buys any interest in the property, buys any interest, who buys the shares, buys any interest in the property of the company, which is a juristic person entirely distinct from the shareholders. So only on this principle, that's
Absolutely.
yeah, that's so the agreement is a shareholders agreement, so it cannot bind the title of the land which belongs to the company.
Yes.
Now, number on the, I've taken so far the High Court suit is concerned, the present suit.
Yeah.
I've taken the court through the reliefs which are claimed. Only few averments in the plaint which are made. At pages 28. It is maybe the internal page 28.
20, yes.
Is running page 28. Running page 28, my lord. Here I record with regard to the obligations with regard to the first agreement between the parties, what was understanding. Then, my lord, the next page with regard to this, the shareholding, the meeting was called on,
What are
everything.
you trying to impress upon us, Mr. Mitra? By
What I'm trying is
It was
that
regarding the
we
share
have
holding.
said that the fraud that has been done on me, why I asked for deliverable and cancellation, and why you want to get rid of these these two agreements. Which continues, my lord. Then at paragraph 35, which page 36, para 35, Lordship has said that the earlier suit is mentioned over here,
Yes.
which is the page 34, para 34, in the last attempt, page 34, sorry, my lord. As a last attempt to secure the consideration as set forth in the agreements of 2012 and 2013, the plaintiff instituted a money suit being number such and such before the Honorable Second Civil Justice as Barasat, being money suit registered number. A copy of the plaint is duly served upon defendant 1 and 2. In the first week of September 2015, the defendant number 1 and 2 have appeared and filed an application for staying for further hearing of the said money suit. From the tenor of the aforesaid application, it has become apparent that the defendant number 1 and 2 are not interested to comply with the terms and conditions and were otherwise exerting pressure on the plaintiff by claiming 10 crore as damages in the suit for specific performance, being TS number 192. This is the suit filed by my learned friend. Then the plaintiff no longer wishes to extend the contract any further. The plaintiff have committed breach. And we have said the allotment done and the particulars of fraud in paragraph 41. So on these pleadings, we have asked for the delivery up and cancellation of these two instruments and other perpetual injunction not to hold out the shares. Now, on these pleadings, I say, my lord, the order to rule to leave is there, which I have already said to your lordship. This suit, another thing I should indicate, my lord, this order was passed during this pendency of this appeal. Shares has further been transferred by these defendants. Lordship, you see the defendants are, there's so many different. Yes.
There's no injunction at any point.
There is no injunction. There was an order. There was no injunction. By defendant number 6 to 37, they have further transferred the shares to another two entities. Bengal, City Nirman and other companies. In fact, two entities. All defendants have further transferred. There's an order subsisting that any transfer will abide by the result. And there's no injunction in that sense. So there may further transfer. When we file an application for adding those further transfer is a party, and the injunction on the further transfer is for creating further transfers. So the multiplicity of proceeding. In that pending.
Their entire shares were transferred, or some of it.
Entire.
So that's why an injunction on them would
by further. Then for further entire holding.
That would suffice because these people have already given.
They have already given. The entire. Now, Now, from very beginning, 185 shares of the company are with me. So that is with me. The rest, 44,000 or 45,000, the entire has gone. When I moved that application before the Honorable Single Judge, my lord, the issue came up whether this is a commercial suit or not a commercial suit, whether that can be pending. An order was passed. That is the reason I filed a IA. A new IA is filed here. An order was passed. Oh, there's an IA also, my lord, which is IA 2, which is, I think, in the list. This is filed in 84, APO 84 at IA filed. Yes. At page 38 is the order. Oh, this is sorry, page 38 is the order admitting the appeal. But you will kindly see the order admitting the appeal of Justice I.P. Mukherjee's. And the next page records that
this appeal, the present appeal.
Yes. Then when we moved the application for injunction, the order was passed at page 40. Page 39 is also Justice Mukherjee's. Page 40 is Justice Sugata Mujumdar's order, my lord. It records the division bench in terms of the order of 12th of July 2021 passed an order to the effect that the respondent shall proceed with the application and the suit after decision of this court on the maintainability issue. Clarification may be obtained as to whether the present application, should be heard and considered by this court. Because my submission was the suit cannot be heard. So the proceedings in the suit got stayed, so that I made this application. So any event so this application is made by me for a clarification whether I can go, because once the appeal is getting heard, this become academic. This will become academic once the appeal is getting heard. So that only the intervening fact is the shares has further been transferred.
That's
That is the
also not on record.
no, that is on record before the in this suit it is on record. May not be record in the appeal court, but in this suit this is on record. The application which are pending.
So that means is that in the
order
this stage,
impugned.
at the stage of the order impugned, it was not 7-11 only.
Yes, at that stage it was done around a year back. It was done around a year back. Now, my lord, yes. Now we come back to the last point of the second appeal, which is the commercial. Now, my lord, I have taken instruction, my lord, whether it's commercial or whether it's non-commercial. I'll say it's academic, because if it is Calcutta High Court, it becomes the same judge from one court to the other court.
Not at all.
Only I have to change the, because I'll tell you.
Not at all.
Yes, I'll tell you why.
That's beyond the paradigm of 2015 Act. That's the difficulty. That's why we have separate commercial division, commercial appellate
No,
division.
I'll tell you.
There would be no necessity of that.
I'll tell you what. This suit was filed when? I'll just clarify this. This suit was filed in 2015. The Commercial Courts Act came after that, when the date was filed.
After filing of the suit.
Yes.
So then the transfer applies.
That transfer applies. I say the transfer applies.
That's why that has been
That has been applied. So
applied.
I say whether it is a commercial or non-commercial, it doesn't matter to my client.
You have no.
I have no problem. That is the only thing. I have no problem. That is the reason I say if it is commercial, I change the nomenclature. Section 15 applies. It gets transferred. Statement of truth and other affidavits has to be filed. I change the top sheet. That is the change has to be done. Whether it remains a non-commercial, it remains with the same court. The same. Now, making that submission, whether it becomes commercial or non-commercial, is for me, for my client, is academic. Now, if we go back to the Commercial Courts Act, even I can say it is this 12 shareholders agreement. It's a shareholders agreement. Now, if it is a shareholders agreement, I have not read this decision, but
According
I think
to you, Mr. Mitru, is a shareholders agreement.
But to be very honest, man, I have.
You are holding a senior gown, therefore you have to be honest on that.
Yeah, I am honest.
There is also you have to be honest. But now you are a friend of the court.
No, I've not.
Same footing on law.
No, I have not.
That
Very
is
honest,
purely
man.
on law.
And yes, on law, on a shareholders
Shareholders
agreement, that is the reason, Malad, I said, Malad, next Wednesday, 10 minutes on this. If it is what Mr. Dotto is saying is right, I will not utter a single word. I will not utter a single word. What just Karnataka na Kerala, na Karnataka. What Karnataka High Court has said, if that is the law, and if what's Black's Law Dictionary is there, I'm not.
And if what Black's Law Dictionary says is correct, then
Then this
Black's Law Dictionary has been quoted by Karnataka.
Karnataka has been, it's
Therefore,
quoted by Karnataka, but I'll
also
try.
to check out whether Black's is correct.
But first is black is correct. Then it
Black is correct.
OP this law lexicon. This
Yes.
that is also.
Whatever.
So only on this, the shareholders agreement. I don't think, but what
It will
was
be an exhilarating experience for us because this is the first time Black's authority is being challenged before us. It will be a pleasure to us to hear and also an honor for us to have a challenge to Black's
also.
interpretation of a
Now,
particular-
my lord, only on 7, I think.
It was Justice Ajay Nath Rai, my lord. A passage from Justice Shah Rai's book was handed over.
Gallo.
It was handed over by somebody who was not from this court. He's come from outside.
Achha, that's why.
And the judge, the moment he closed the book, is he dead? I did not know when did he die. This lawyer was absolutely taken aback. My lord, I don't know. No, Mr. Shara used to sit in the library. Go find out whether he is dead or not. He still could not understand. Then he said, I don't know the name of the gentleman, that so and so. It's an opinion of the author. So long he is not dead, it doesn't, you cannot cite it because tomorrow he can change it also.
Now, my lord, if we look into this 7, the
seven.
227, which was my lord was that
Yes.
221
Right.
C7. It
That
says
apparently does not apply
does
because
not.
it's not. It's premature to say it's
Yes,
for
that is
commercial.
not.
As you said.
whether how it is being used, whether that
It will be used.
it will be used, and it is not an agreement relating to immovable property. The threshold agreement within immovable property. The rest. Then comes
Yes, because the other argument will go itself.
we will go. It has to be agreement relating to immovable property.
I was waiting for
Right.
Then the next
Okay.
question is trade and commerce or charity or hospital or a school. What is then? That's the secondary. First is relating to that. So if at all I can come in, I'll come into shareholders agreement. At all, because the definition is, they have given a definition. We cannot go beyond these 12, 22 subheadings. We cannot go beyond these 22,
No.
21 rather.
Means
21. We cannot go beyond these 21.
not means and includes.
No, don't means it. No. It cannot.
Interpret.
Is it 21? Within these 21 subheadings, I have to fall myself. So the pleadings, other things will not come. Only if I come under. With what I understand, at best it is 12. I'll check, Mala. That if I cannot, I will not utter a single word. I should not.
When would you like to come back?
Next Wednesday, Mala. That.
Oh yes, we have to.
Before he takes a minute, there are two authorities, Millard, I would cite in reply. I'm giving him a copy right
Yes,
away
yes. Do that.
so that he can. One is Millard, really he's dealt with ADCON. Now ADCON has been subsequently discussed by the Supreme Court. And what the difference is this, Millard, so far as ADCON is concerned, ADCON was following 60 Calcutta, that Devendranath Ghosh judgment, to say whether it's a suit for land. Now, the Specific Relief Act, Millard, was amended in 63. And there, Millard, section 21 was couched in such a manner that it included the prayer of possession in the prayer for specific relief also. So that was the difference, Millard. Why? And so I'm handing over because I will be citing that in reply. And Millard, the other judgment I have cited is a Delhi High Court judgment which says that transfer of shares of a company, Millard, includes the land of the company as well. Otherwise, what are they telling? The all right title in it. But that would not apply because the company itself is a party in this proceedings, is one of the defendants.
The company was a party to the first agreement, Mr. Dutt. The second agreement says it supersedes all the terms and conditions of the
Very
previous, and
similar.
company is not a party there.
But in dispute, the company is a party.
Yes, but if the second agreement supersedes the first agreement, the company is not a party to the second agreement, then Bacha Gazzer will also have to, think about
I'll think.
how far that is applicable.
How I'll think.
You have other arguments on that also. Definitely there are.
I've just given it 2 copies so that he can
Thank you.
finally conclude and I'll come back.
Supreme Court.
Would we request you to come with written notes of arguments on the
As
same?
you like.
Or would you like to complete and then if something is added?
No, I'll come with it.
Come with
Uh,
page.
Third in part, push up. The matter shall be listed next on August 25, 26. Sorry, August 26, 26th August.
No, 27th is holiday.
Achha, we don't know if keeping it on August 26. If not, then the
26th is holiday.
on August 26, 2026 for further hearing and for filing of written notes of arguments by the party.
আমাদের 27 ডিক্লেয়ার করলো না হাইকোর্ট?
No, nothing declared. That has been
Oh,
kept
nothing.
open. Then that is we keep those things open.
To be notified.
To be notified. To be notified is the right thing.
It's kept on 26th.
Yes,
Then
we have to
we-
keep it on the next Wednesday.
next
If it's not available, we'll go on to the next till further.
Second.
And Mr. Dutt, you more importantly, you also have to deal with the judgment of Supreme Court cited by Justice Nagarathan.
I've read it.
You have to deal with that also.
Para 7.
The order to rule 2 cannot be a ground for rejection under
In para 7 says, thereafter para 7 says that if you are to read both of them together, if the order to rule 2 ground is on a plain reading of the plaint, then it is a case under order 7.
No, a distinction has apparently been drawn between where the reliefs are barred and the suit is barred.
Yes, that I've seen.
So we asked Mr. Mitra a question that suppose you admit something clearly and the reliefs are barred, then we don't reject the plaint and we wait for the hearing and then go and say no, the reliefs were barred from the inception. So this step we are rejecting the
Absolutely.
reliefs. So that has to be we have to read it harmoniously. Judgments also should be read harmoniously. This is a new
Of
profession
course.
we'll
Of course.
pronounce in our judgment and apply that.
Obliged.
Thank you. Next. Yes, first.
I appear for the appellants, Lord, in all the matters. Lord, I'm I formally pray, my lord, for not today because I'm being led by Mr. Mitra.
He has a history of opposing these things. And
On earlier occasions also he had a
I leave it to your lordship.
don't leave it to us. We are happy to grant adjournment.
No, it was almost done last day.
It will
Mr.
still remain almost done if you ask for time.
আমি কি করে হ্যাঁ বলবো?
Lord Mr. Mitra.
Your expressions in these situations are priceless. You have to see the expressions.
I can-
Adjournment is asked.
I can start, but Lord, if
Well, difficulty is that everybody now watches on the
YouTube, Lord. I can start,
You
but
have to
Lord,
make a
it'll.
face to
what face, Miller. I cannot say yes, Miller. I cannot concede.
No,
to his
the subtle interplay of emotions in your face, Mr. Dasgupta.
No, let him start, Miller. He may not conclude. Let him start, Miller. Anyway, he may not.
Only with this assurance
Not
that
want
Lord,
him to start even.
no,
I'm asking Miller. Did start
Lord,
করো না?
If he starts somebody else, then it will be confusing for us. He'll argue something.
No, I request Miller. Let him start, Miller, on this. It was done last day.
He has started already.
Mr. Mitra had Lord started, Lord, and Lord he was
You are led by Mr.
Lord
Oh, Mr.
Mr. Shurjit Mitra. Lord.
Yes, yes.
He had started on the last
Because
occasion,
Miller
it was
to Miller
taken up.
be part
at
of
the-
Miller in
What will be the
Jodhpur.
use of his starting? He has already started. Again, it will be restarted by Mr. Mitra on the next occasion from the inception.
There is substantial time that he may conclude also, Miller. There's nothing much left.
That is what he doesn't want.
No. But if I start, it will end. That is why Lord I'm.
To start, we'll ensure that he ends. Yes.
Lord may kindly.
On the prayer of the
Record in his name, Miller.
Yes, yes, Lord.
On the prayer of the
Appellate.
Appellants, Lord.
yes, therefore, of the appellant,
3 to 7.
the matter is adjourned.
Next Wednesday ছুটি বলছে।
Adjourned for the day. We'll just make it adjourned for the day whenever it happens. That will sound good to your client.
Yes,
Adjourned
Miller.
for the day will
I
sound
have not
better than
conceded. I have not.
adjourned
I have not
till
conceded.
25th.
I have not conceded.
Grateful.
This is
Should we record that it is seriously opposed by
yes, yes. That will be.
আচ্ছা a prayer for adjournment প্রথমে কি করবেন
But that has not been
না
done.
এইভাবে করবেন এটা কেটে দিন Learned counsel for the appellant seeks an adjournment which is seriously opposed by learned counsel appearing for the respondent. One respondent.
I am for all.
Respondents. Push stop. However, comma, keeping in view the predicament of the appellant, let the matter stand adjourned for the day.
Grateful.
This live streaming is causing every difficulty.
Yes. In a different avatar now. No, still for the appellant.
Willard, this is a strange situation, Willard.
Why?
But there were two appeals pending before the court, Willard. Now, Willard, one day the list,
Oh, acha. Now we remember.
and Willard, the matters were called on. My learned friend had an appeal. My learned friend had an appeal, and I also had an appeal from the same YouTube document.
Your appeal has gone out.
No, both were taken together. My learned friend had the chance to address the court. So my learned friend's appeal was dismissed upon hearing. Now the court records that so far as the other appeal, none is there. Since that is dismissed, this is also dismissed.
We said so.
No, Mr. This is
Justice Boshan.
previous.
Justice
This
Boshan.
is another appeal court with the
But if
matter
that
is in
is-
assigned to you not.
Acha.
Now, Willard, what has happened is this, Willard, we applied for restoration. Some untoward, unfortunate incidents happened in court. One of the judges were compelled to release the matter. We went back to the court. The other judge, Willard, who was there, he said that I'm so much biased with the other incident, I will not take it up and I'm releasing the entire thing. So, and thereafter it's come before your lordship. Willard,
We also do something similar so that we don't have to.
আমাদের
Willard,
restoration
kindly,
এর
mine is a restoration.
আরেকটা review
But there are-
থাকলে ওটা
And
করবো।
there is a review.
There are
My
two appeals.
restoration is on a very simple ground, Millard. The learned judge has taken note of the fact that their appeal has no merit. But that doesn't solve my problem because I'll tell you in 2 minutes, Millard, if your lordship please me. I am an auction purchaser in a court sale. When I have purchased this property, there is a proper conveyance in my favor. Now, my lord, when I applied for execution and put in execution, court officers were appointed for the purpose of going and taking a possession. At that stage, my lord, when the court officers went there, the officer, my lord, my learned friend's clients were found in possession. They gave an undertaking to vacate, but they did not vacate. They vacated a portion and thereafter they came rushing to court and filed a Order 21 Rule 9701 application. That application was dismissed on the ground on the court came to a finding that you have purchased the property in violation of an order of injunction. Number one. And number two, there was an attachment violation. And number two is that the conveyance, in order to avoid that, my lord, what they did is they got the property mutated in Purulia. Although the property is not in Purulia, they somehow got it registered in Purulia in connection with another deed which has no connection with them.
All right.
So that was the issue, but the learned judge has come to a finding, the single judge came to a finding that this is bad. You cannot get any title by way of this, whatever you have done. Now, Miller, once this appeal was getting dismissed,
That injunction was against the bank. The
injunction was against the judgment.
oh, sorry, not bank, court sale, judgment debtor.
Yes. And he is claiming through the judgment debtor in violation. So
No,
that
your purchase is bad.
now
Court
what
said that
happened?
your purchase is bad.
Yes. Now what
You are
happened?
not a party to that proceeding, but
No,
you are
no, no,
claiming
what happened is this, Miller, since I was
you
executing.
get the fruits of the
So-
unlawful.
Yes. So what he did, my lord, and when the appeal was being dismissed, they made a submission that he has purchased the property at X rupees. Reopen the sale, I want to bid also.
Achha.
And the court, my lord, on the basis of that prayer, my lord, set aside my registered conveyance without any prayer, without any application, and said that you go and bid again.
Why was their order 2201 rejected?
On the ground that they have come into the property in violation of an order of injunction passed by
They
the.
came into the
They came. Now, my lord, I have a registered conveyance which was not even under challenge. And my registered deed of conveyance was set aside on the ground that he wants to bid and purchase this property. A sale which is concluded 7 years back.
Delhi.
Hey,
So that is it related to Chatterjee International Center?
yes.
I have
I was
appeared
perfectly
for
clear.
municipal authorities in this particular suit at some
This
point of
suit,
time.
my lord, I am a
There
purchaser,
were
so I
several
have nothing to
applications
do
for
with
the
the suit,
report I remember in connection with this suit. So
my lord, this would be a, my lord, with respect, my lord, may I endeavor a little further. My lord, this is an offshoot of that. Property was sold, there is no challenge to the sale. This is, my lord, an order
suit
21.
number, the original suit number I recollected was written and all.
The party, there are these for 200 or 300 depositors. who are-
You are brought in তুই যা মনে করতে এটা আমার কোনো পার্সোনাল কানেকশন আছে কানেকশন থেকে ডাইরেক্ট করেছে
এতদিন বাদে
এসবিআই প্যানেলিটি
না সেটা না
এটা করা যায় সেটা কিছু এদের is the KMC interest affected in any manner that we are confident that you will be saying if it is? Can there be is there any scope that KMC is right
KMC, no, it's a question. I have not yet come across because I am only.
KMC was neither the judgment debtor nor anybody in there.
I do this. I'm sure it is not. But since a query has fallen from the court, let me be doubly assured that KMC is lower. Kolkata
Because
Municipal.
at one point of time there were some repairs and all these things, so that is why KMC was brought in, and I appeared for KMC in those
Yes,
applications.
because it is that building will or
Yes,
Chatterjee
in respect to
building
Chatterjee
will or which is
International
there,
Center.
that has an administrative suit pending for administration of the affairs of the building. In that connection, your lordship.
No relief has been claimed against the KMC.
You
at any
remember the
cost.
suit number, but
party
the
to this process.
party's name.
But if your lordship looks at the suit cost title, Millard, KMC is not even a party. Probably, Millard, what I'll have to find out whether that administration is part of this suit or administration is part of, because I remember there was a separate suit filed for administration of the affairs.
KMC is not a party in the cost title. KMC is not there.
No.
Richard.
No, okay.
Yes, sir.
Yes, my lord. My lord, there's a
They had
review.
appeared also.
No.
There's a review, my lord, from the same order, my lord, which is before my lord. Item 8 and my lord, one more item, which is filed by us.
Yes.
My lord, both the appeals were taken up together and my lord, disposed of together. My lord, we had filed a review because certain facts, my lord, which were glaring on the face of it, my lord, were not considered. That is
Review of whose order?
of the order, my lord, dated February 13,
Of the
2026.
other bench.
Of the other bench. which-
Review has also been
yes.
assigned to us.
Yes, my lord. Review has also.
So then we have to take up the.
Yes, my lord. So, my lord, I was saying, my lord, Mr. Dhruva Ghosh, my lord, is leading me in this matter, my lord. He has some difficulty today. When my lord is taking up this appeal, review will also have to be taken up, my lord, together. That is why.
My lord,
Review of a different bench.
I told your lordship, my lord, the learned judge was so upset with the incident that had happened, my lord.
Yes.
He didn't want to take up anything connected with this.
Oh, acha.
So he had also released the review.
So furnish some material for us to be angry also so that we can also release. It will take some time. So we are already hard pressed with matters.
My lord, kindly restore my, my lord, my restoration also got released, my lord.
Mr. That will take up the restoration along with the allow the restoration immediately take up the main matter.
Fine.
Otherwise,
Then I'll keep myself.
maybe your restoration is allowed and this appeal cannot be taken up. So we'll take up both together.
Fine.
So
My lord, next, or my lord, next Wednesday, my lord,
started hearing basically.
next Wednesday, my lord, we are presuming that there'll be a holiday, my lord.
So what is the difficulty if it started today? Because Mr. That has opened the case.
Lord, if I have to answer, Lord, Mr. Ghosh will be leading me. That is why, Lord, I'm saying.
Mr. That are you prepared in the matter?
My lord, I only to show the judgment, my lord.
So I think we can start hearing. If you are prepared, then we can hear it. We have
Lord, kindly
half an hour
allows,
more.
kindly allows one occasion, Lord. On the next day, we will answer our, Lord, we'll press.
He won't get the time to
Oh, my
conclude.
lord, my junior tells me, my lord, that the appeal court record, I can move the restoration, but the main appeal papers are probably. Achhe. Oh,
So it's
chalo,
there,
chalo.
it's there. We can start hearing. Start the hearing. Restoration, what is your ground? Let us see.
My lord, your lordship will see, my lord.
Restoration filed within time.
Yes, yes. My lord, kindly take the order at page 77 once, my lord. Two appeals. While under the top, your lordship will find the two appeals. APO 489 and APO 486. Ours is 48? 486. Two appeals are taken up together for analogous hearing as they emanate from the same judgment and order of 28 July
So
2015.
this is a dismissal on merits.
No, my lord. Their appeal was dismissed on merits. I'll show that.
Both
Not-
are the last sentences, both are dismissed without any orders to cause.
Yes, but thing is this, my lord.
The entire discussion is on their appeal.
Yes. Because the learned acts. Either you are ready to do the matter or you are not.
Yes, exactly. We say precisely the same thing to you. Either you are ready or you are not ready. If you are ready, we'll take up the matter. We are taking up the matter.
Learned advocate appearing for the appellant submits this appellant is my learned friend's client. Appellant purchased the immovable property at least 10 years prior to the purchase of the other appellant. He submits that there are no ground for setting aside the sale in favor of the appellant by the joint administrators. Then none appears for other parties. The appellant in APO 4886 is not represented. This is our appeal. The appeal is pending since 2015. By the impugned order, the learned judge found that in a suit instituted by the depositors of a company, Chatterjee Prog Private Limited, for realization of amount invested by the depositors, joint administrator appointed, John put up the immovable property for sale. We find from the records in the suit there subsists an order dated 23rd December 1982 of injunction restraining the defendants from dealing with, disposing of and encumbering the properties mentioned in Annexure D to the injunction application. There also subsists an order of 14 December 83 directing the joint administrator to take possession of the asset mentioned in the report of the Deputy Superintendent of Police, Bureau of Investigation being Annexure B thereto, and other assets which they would recover pursuant to the orders and directions made in that behalf. Learned single judge construed the order of 14 December 83 to be omnibus in its terms, as it includes all other assets which may come to possession of the joint administrators in future. Learned single judge noted that there was an embargo on the part of the defendant number 1 and or its nominees from dealing with or disposing of any of the properties belonging to the defendant number 1. Learned single judge noted that one of the companies was controlled by the defendant number 1. Learned single judge also noted that such company was nothing but an alter ego of the Chatterjees. In such circumstances, the learned single judge held that the alienation of the immutable property concerned fell within the mischief of the subsisting order of injunction and direction passed. Learned single judge held that the sale was in defiance of the order of injunction. We find no materials on record to take a view contrary to the return by the learned single judge in the impugned order. Sale was conducted in breach of subsisting order of injunction and direction passed by the High Court. In such circumstances, we find no ground to interfere with the impugned order. Then APO 489 and 486 are dismissed. So there is no discussion on 486.
Their appeal stands dismissed.
Dismissed.
So a review application has been filed by them on
Them
in-
on this.
And yours is virtually a dismissal for default in a sense because it was recorded, you were not represented.
Present, yes. This is order 9, rule 9 scenario.
লেখা নেই কিন্তু এটা তো নষ্ট করা যদি একটা লাইন অফ রিজনিং নেই it is not written that it is dismissed for default. This is the difficulty. The order is composite one.
Yes, Millard. Yes, Millard. But not a one single line even there, Millard.
Had there been any expression that the appeal is dismissed for default, then it would have been all right.
Millard, dismissed for, I think, Millard, this would be an order 9 rule 8 scenario, Millard. So, Millard, it records that none of the parties have appeared.
That is correct.
Independently, we can also recall the order. I mean, by saying that it was not at least on merits at all. Suppose we were the bench which passed the order.
At least the learned judge Millard thought so till such time he released it. He says that was, there is no reason in that. He was actually not intending to dismiss it. Since that was dismissed,
Very obvious.
and there was nobody to assist the court as to what was the scope of my appeal. In fact, that their dismissal should automatically.
No, Mr. Dutt, even if you are not there, nobody was there to assist. The court addressed 1 or 2 lines, or
If he could have been, then probably I would have come on merits in review. All
something on the merits of your appeal. It's not touched even.
It has not touched. Yes, Lordship is right, Millard, that default word is not there, but it can be construed that it is being dismissed for default. Because it records that none appears.
Registration ছাড়াও তো record আমি তো record করি এই পেশেন্টটা শুনে মনে কি তখন record করে এটা তো একটা রাইট
Yes, what do you say on the registration or recall, whatever you say? We are allowing that. Your review has to be heard on merits, order
Yes.
47.
Review has to be heard on merits. Millard, if my lord is recalling the order, Millard,
We intend to, subject to what you say.
তাহলে তো
You are not yet recalling. Whatever you say. Yes, yes.
Millard, I was saying, Millard, when if my lord is going to recall the order, Millard, virtually both the orders,
Not touch the merits of
orders
their
in both
appeal.
the appeal, Millard, will get recalled, Millard. I was just asking them.
We'll make sure
Because
that
Millard-
it's not.
Both of them have been taken up together.
Their appeal dismissal will only be recalled. And the review application will be kept alive.
Yes, Millard.
The portion of the order
Yes.
whereby APO 489 of 2015 was dismissed
Yes.
stands recalled. That will be the order.
86.
486,
Mine
Millard,
is
is their appeal.
486.
489 is mine.
First that will be, oh sorry. The other one.
486 is theirs, 489 is mine.
Thank you for pointing out, others we'd have to recall this order again.
Lord, I was saying, Lord,
You say whatever you have to
Your
say,
Lordship,
we'll
may
hear that
kindly-
and then pass our order.
Lord, Lord, in that case, your lordship may kindly, my lord, takes this application as well as the review together, my lord, so that the day, my lord, when your lordship will be allowing that, on the same day, my lord, both the matters can be taken up. Review as well as the appeal, because the appeal cost papers are also here.
Very well, Mr. That will record. Learned senior counsel appearing for the petitioner in GA2. Yours is GA?
Mine, this restoration application is GA2.
GA2.
GA2 of 2026. In connection with APO 486 of 2015,
Yes.
submits that on February 13, 2026, comma, when the order thought to be recalled was passed, comma, the none appeared for the appellant in APO 486 of 2015, comma, which will be evident from the said order itself. Full stop. Moreover, comma, not a single sentence was devoted to APO 486 of 2015 or the conspectus of the challenge therein. Full stop. The entire observations made in the order dated February 13, 2026, comma, it is pointed out, comma, advert to APO 489 of 2015, comma, the appellant in which was represented. Full stop. As a consequence of such observations, comma, the coordinate bench dismissed APO 489 of 2015 on merits. Full stop. Next para. However, comma, insofar as APO 486 of 2015 is concerned, comma, it is pointed out that the same was dismissed without recording any reasons whatsoever as to the same and stroke or adverting to the same on merits. Full stop. Next para. Although it is evident from a bare perusal of the order dated February 13, 2026, that APO 486 of 2015 was not adverted to or intended to be decided by the coordinate bench by the said order, and in effect, comma, the said appeal got dismissed on a day when the appellant therein was not represented, comma, since at this juncture an adjournment is sought on behalf of the respondent in the said appeal, comma, which is also the appellant in APO 489 of 2015, comma, we adjourn the matter for the day.
আমাদের appeal
Full stop. GA2 of 2026 in connection with APO 486 of 2015 shall next be listed along with the review application filed in connection with the other appeal on August 26, 2026.
But just one blood correction. I'm not a respondent in their appeal, blood. There are
No.
two
Oh, achha.
independent appeals.
Respondent in the appeal, the appellant in.
Grateful. Blood.
That's correct.
We have recorded virtually everything, but we'll just pass the order on the list.
Great.
Oh, bless.
My lord, in this matter, the state is the appellant, my lord. The fact remains, my lord, we are still not in receipt of the papers, my lord. The erstwhile we have searched.
You are appealing for the state.
I'm for the state, my lord. My lord, we are.
Will not receive so long.
No, my lord, there's so much we have. We are perusing the office of the erstwhile advocate on record as well as the legal remembrance cell. They, in fact, they have written me a letter saying that you procure the documents and send it to us, my lord. So, my lord, the only
When should
matters I
you
was
tell
seeking,
us?
my
We'll
lord,
give you a fortnight.
can we take certified copies of the record from there? It's the only way out, my lord. If the
From our
document
record?
doesn't leave out,
Learned counsel appearing for the state stroke appellant submits state stroke appellants submits that counsel is handicapped due to lack of any papers. Full stop. Next para. Despite earnest efforts, comma, it is submitted that learned counsel could not obtain the papers connected with the present appeal and seeks to obtain certified copies of all the papers. Full stop. Next para. Accordingly, the office is directed to furnish certified copies. আমাদের rules এ কি permit করে? Permit করে না। Proceedings furnish certified copies all the relevant documents pertaining to APO 14 of 2017, which are applied for by the parties at the earliest. First of next para, the matter shall next be listed under the same heading on September 16, 2026. Full stop. In the meantime, comma, the file be sent down to the department for the purpose of issuance of certified copies, comma, subject to being sent back to the court before the returnable date.
Deeply obliged. Deeply obliged.
Yes.
Number 10. For the response. Lordship, in this matter, I along with Mr. Chakraborty recently briefed in this matter. If your Lordship
Why did you take the brief? If you could not prepare yourself, why did you take the brief?
and
If you are not confident that you will be able to prepare yourself
Lordship,
before the
NOC is,
court takes up the matter.
your Lordship, this is matter is regarding to dispute between brother and sister, and talks of settlement is also going on, your Lordship.
That's your second limb of our
No, 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 my
argument.
no.
Why aren't you prepared in the matter?
Just
We can indicate the facts.
I have, and I have to file my Vokalatnama also, and NOC is required from erstwhile advocate, your Lordship.
Then you don't have any locus standi to appear even today.
If your
How
Lordship,
long will you require to get that NOC?
2 weeks, if your Lordship kindly grant me leave.
We cannot even record your presence. That is the difficulty. Because you don't have without an NOC, you don't have a right to represent the client.
Vokalatnama is ready, your Lordship.
NOC Vakalatam is ready.
No. NOC is required from erstwhile advocate.
That is the only important thing. Vakalatam obviously ready. Otherwise, the client came to you and no, without NOC, we cannot record your presence.
Appellant three dike.
What is your surname?
Fine, Mr. Das, Shubhankar Das.
Mr. Das, Mr. Chakraborty, and what is your surname? Oh, won't do. Mr. Das and Mr. Chakraborty, comma, learned advocates, comma, submit that they have instruction to appear on behalf of the respondents upon obtaining a no objection certificate from the erstwhile learned advocate. Which of next para, however, comma, in view of such no objection having not yet been obtained, learned counsel seek an adjournment in the matter. Full stop. Accordingly, let the matter stand adjourned till September 9, 2026.
As your Lordship.
Your Lordship, with my seniors leave, may I just pray
Yes,
for
yes.
one thing? Lordship, may my name not be recorded because I am perhaps not allowed to, Your Lordship, file a Vakalatnama.
Oh, very well. Chakraborty Devat, Das. Yes. Great. Thank you. Yes.
Grateful. Your Lordship. ARI.
Ma'am, you give your name also for the appellant. And Mr. Das, you give only your name then.
As your Lordship.
You don't have authority to authorize him. So that his name cannot be recorded in any way. Acha, unar namta na, you just write under your name, having instruction to appear for the respondent. Write this, not for the Mr. Shubhankar Das, .. having advocate having instruction to appear for the respondents. Or appellant advocate for the appellant. Yes, next.
Grateful, your Lordship.
Thank you. Ashmit Dar. কি বলি বলতো এই তোর সাইন ম্যাটার আর্টিকেল খাওয়াতে পারছি না লাস্ট চান্স দিয়েছিলাম দুবার হয়ে গেছে ডিসমিস করে দিচ্ছি আর আপনি রেজিস্ট্রেশন করুন যখন রেজিস্ট্রেশন করবে তখন we find from the order dated December 24 sorry we find from the order dated December 24 to 25 comma that even after assignment comma none had appeared for the appellants although the respondents were represented by counsel. Full stop. Accordingly, a last chance was given to the appellants to argue the matter on the next occasion. Full stop. Even thereafter on May 13 2026 comma you are for the respondent.
I have a cross appeal.
May 13 2026 comma none had appeared for the parties at the time of call. Full stop. Again comma the same exercise was repeated on May 20 2026 comma when the matter was called on but none appeared for either of the parties. Push up. Lastly, comma, on August 12, 2026, comma, the matter was adjourned on the prayer of the appellants. Push up next para. Even today, comma, none appears for the appellants, although the respondent is represented through counsel. Push up next para. In such view of the matter, comma, there is no other option before the court but to dismiss the matter for default. So, GA has been connected in connection with this appeal. Accordingly, APO 43 of 2021 and IA number GA2 of 2022 are dismissed for default without any arrest of cost. Interim order if any stands vacated. Back on system. সেটা default করতে থাকি then হবে বলে চেষ্টা করে দেন আপনারা discussion করতে। On August 12, 2026, we had recorded that it was the second occasion when none appeared for the parties at the time of call and a last chance was given to the appellant to argue the matter. Which of next pair event today at the time of call, both the parties remain unrepresented. Accordingly, APOT 90 of 2021 is dismissed for default without an order to cost. Interim order if any stands vacated. Next.
The 13 responded. December, your lordship had directed them to serve me. My lord, mailed them asking my lord to be served. Thereafter, they have not served me. They also, my lord, not appearing. My lord will see the last order, my lord, of 22nd July.
The appellant remains consistently unrepresented, comma, at least on the last 3 occasions. Which of next parallel and counsel appearing for the respondents hands over the printout of an email from which it transpires that an information was given to the learned advocate for the appellants as to the appearance of the respondents. First up, next para, a copy of the memorandum of appeal and the stay petition was also sought. First up, however, comma, it is submitted by learned counsel for the respondents that no such copy was handed over to the learned advocates for the respondents. First up, next para, since the appellant chooses to remain unrepresented even today, comma, we have no other option but to dismiss the appeal for default. Hence, APO 132 of 2021 is dismissed for default without any orders to cost. Interim order, if any, stands vacated. The printout of the email handed over in court today be kept on record. Great.
Lordship, only one indulgence. Mr. Mukherjee is there. Mr. Mukherjee is there, my junior. There has been 2 emails. Twice we have served them, both the times. There are 2 emails.
Second mail, my lord, the date has got.
Since Lordship is
Second,
keeping
the
it in
printout, there is
record.
some difficulty in the second date. That's why your learned junior did not hand that over.
Very well. Very well.
1, 2, all the same. When they file a disclosure, will allow it probably, but then we will immediately take up the matter. You also come prepared. Great.
Grateful, Lordship.
Thank you. Next.
Item number 40, I am appearing on behalf of the appellant, Lordship. In this matter, Lordship, one of the senior he is appearing as now becoming a judge of this Honorable High Court, Lordship. So the
Which judge?
Honorable Justice Parthovatim Roy, Lordship.
You start the matter, we'll adjourn.
No, Lordship,
Otherwise, we will record your prayer and
Lordship,
dismiss
I
it
am
for-
not a advocate on record, Lordship. Mr. Shivaji Kumar Das is advocate on record and Shivaji Kumar Das. So I am just instruct from
You are
the
the chamber junior of Mr. Shivaji
yes,
Das?
Lordship.
Then you have to start. By default, you have to start.
Lordship, and just
Start it, will grant time.
Lordship, in this matter, Lordship, we have
That's the rule
informed
for the juniors here. If you ask for an adjournment, you have to start. If we are satisfied that you are ready, we grant adjournment.
Lordship,
You're passing it over for 2 minutes. Prepare yourself in 2 minutes.
Lordship.
You have a file. Why are you hiding that then? Put it up.
I just not hiding.
You start the matter. What is the matter about? You must know. You're in the.
Lordship, in this matter, Lordship, the earlier occasion, the probate was granted by this by the learned court below, Lordship, and the
Probate.
yes, Lordship. Such probate has been revoked by the honorable single judge by this honorable court, Lordship, and that has been challenged by this appellate court, Lordship. And on the ground of this, Lordship, the learned honorable judge has revoked that the legal heir of one of the legal heir is not a legal heir of the deceased person.
Legal heir.
Yes,
Legal heir.
sorry, legal heir, and neither granted general citations or not special citation was issued in this regard.
Due to lack of citation, it was revoked.
Yes, Lordship. On this ground, the
So what is your answer to that?
Lordship, and that I am not instructed, Lordship, in
Fair enough. You have started sufficient. So you get a right to get an adjournment. You are for the other side.
I have not filed my wakalatnama yet. I have been instructed to take NOC and file my
Then
wakalatnama.
we cannot record your name now. Very well. Although the hearing is commenced, what is your name?
Dipendu Sarkar.
Dipendu
Sarkar.
Although the hearing is commenced by Mr. Dipendu Sarkar, only your name.
Yes.
Dipendu Sarkar, learned counsel for the appellant, due to paucity of time, the matter cannot be concluded today. Full stop. Accordingly, the same stands adjourned for the day.
Okay.
For today.
He appeared for the response. 15 minutes I appeared for the appellant. Manut.
Right.
On the last occasion, Manut, there was a liberty granted to the appellant to file the supplementary paper book. Manut, I am filing that same. 2+1.
Original paper book to আছে original paper book to আছে
So that paper book, original paper book.
এটাই শুধু আচ্ছা yes. What is the matter?
Matter is about Manut, a suit was filed by the tenant against the landlord, Manut, for specific performance of the agreement, Manut. It was decreed ex parte.
Terms of agreement for purchase.
But if
You are the tenant.
I am the landlord,
Tenant filed a suit
tenant
against
filed a
you
suit
for
against
specific
me,
purpose.
and it was ex parte decreed. That,
Specific performance of what contract? Contract of purchase by the tenant from you.
but to be very frank, Manut, I have just got the.
Don't be very frank. You tell us what is the agreement.
But I would need some time to reconsider. I would just say about
You
the
can
fact.
anticipate that the matter would be called on.
Yes.
You should anticipate in these sort of tricky courts. You never know what the court will do. So you have to come prepared at least. You have to have basic preparation.
I could not get the suit.
Your
for-
senior is prepared, you are not prepared. He's much senior to you.
He was engaged.
Why?
I had a leader in the matter. Not
What
Devnath.
is the suit about?
My lord, the tenant was originally the tenant of the entire premises. Then he entered into an agreement with the landlord. The landlord will take over the premises, demolish it, build a new building,
Give you back.
and give you back
Similar.
15,000 and give some money for rehabilitation. Now
Developer was also a party there.
that ex parte decree was passed. They filed an application for recalling the ex parte decree, Order 9 Rule 13, which was dismissed for default after 6 years. Dismissed for default. Thereafter, they filed an application for recalling that ex parte decree and a Section 5 application after 6 years.
The
12
original
years.
decree.
Yes, or after 12 years. That has been dismissed by Justice.
Recalling that original decree.
No. Recalling the application of dismissal and Section 5 application.
Achha.
Now that was filed again after 6 years. After 12 years, the matter has been
6
finally.
years is the normal interaction.
So the finally.
Appeal has also been filed 6 years after that.
No.
They're not so consistent.
So that has been dismissed by the learned judge that no sufficient ground has been shown.
Yes, you come prepared. You come prepared. Come well prepared.
Yes, madam. In 2011, the decree was ex parte was passed. Then
You have to convince us there is even a single reason for why we should allow
that
this.
has immediately the learned judge exercised this discretion. There's no ground.
Exercise of discretion and justified.
Normally, my lord,
6 years, 6 years,
not 6 years, my lord. 2011 decree was passed.
5 years,
ex parte-
11 months.
2011 decree was passed. 2011 recalling application was itself passed. Then the matter was never taken up. In 2017, the matter came up. The learned judge recorded that as the suit was decreed, let the application be dismissed.
That was the order. That is at page 44 of the
Thereafter
paper.
in
First paper.
23 file they filed.
And
their
this was
application.
not communicated to the advocate. I say there is delay. From there, 2017 to 2023, there is a delay.
What is the reason for the delay?
The landed advocate on record that was present that did not inform the appellant.
Same advocate is still there.
No, no, no. I have taken on.
Give a notice to that advocate. Or usual practice.
Anyway.
Since certain allegations were leveled in the application for restoration from which the present appeal arises, comma, we direct the appellant to serve a notice of pendency of the appeal, comma, along with a copy of the paper book on the
But appeal was filed by me.
on the erstwhile learned. Oh,
Appeal was filed by me. But the
Yes.
recalling application that was filed, that was by different advocate. Recalling application of the decree. 2011 decree, 2011
a
application.
copy of the paper book যেটা বললাম shall be served on the erstwhile learned advocate for the appellant, comma, against whom allegations were leveled in the recall application from which the present appeal arises. So have a copy of this.
Very
This contains a copy of that recall application also.
Yes.
We'll hear that
everything.
advocate and then only consider whether we can.
I got a copy of the supplementary paper book. I
I had given.
Paper book, along with supplementary. Copy has been given to him.
Yes, yes.
Check up if not given, give it.
Madam, may I pray one side? Item 18, one order extension was not under to be extended.
One. Supplementary paper book. Serve করতে? Oh, and actually supplementary affidavit certificate. Yes.
Mala, item number 18, only the order of status quo to be extended.
When does it expire? When does it expire? Don't make that.
It expire.
Definitely extend it. Yes.
Mala, it expire due to tussle with the advocate client.
Has expired.
Expired. But it is only a status quo, order of status quo with regard to
When did it expire?
Malu, only I got the change brief only last early 13
We will
June,
begin
13
the
June,
expiry of the tenure of the earlier advocate. When did the interim order expire?
13 June 26.
No, we'll take it up. When you take it up, we'll consider.
June 15, 20.
My lord, I like to mention one item.
So Bhattacharya will start with.
Order for.
Yes.
I am mentioning a matter. Though I have come before the lordship after 34 days, I suffered from pneumonia.
Oh,
Now, my lord, item number 132. I come today for doing this case. 130 appeal application condition of the writ. 132.
So Bhattacharya, we are not upgrading matters. We are not upgrading matters. If we make an exception for you, that will be unfair to the juniors.
Next Monday, your lordship can read.
We can't assure you, Mr. Bhattacharya. We are trying to take up touch matters as much as possible, but there are so many heads. We are not being able to reach all heads. So we shuffle the heads, shuffle the matters. We are trying on level best. But
Read matter will be taken up for when, my lord. Read matter.
in due course, serially, I mean, certain days when there are too many accumulations, then we keep one heading above the other and we like that we shuffle. Sorry, Mr. Yes.
May I have my lord's kind leave to mention, my lord, one second appeal. My lord may remember on 4th of August 2020.
Order 41?
Yes, my lord. On 4th of August 2025, my lord was pleased to direct the appellant, my lord, to correct the cause title to serve the same. And
So it will appear under the heading Order 41?
Yes.
Yes, it's hand over.
My
You were there first, they will come back to you. Yes.
The order for actually on 7th of July, I mentioned your lordship allowed, but wrongly I mentioned it 507, it will be 517. That's why I'm saying.
Hand over.
My lord, assailing an order, my lord, the state preferred an appeal. My lord, the incumbent is this, my lord, during the pendency of that appeal, my lord, the learned single judge initiated contempt proceeding, and my lord, several times extended the time, my lord.
Appearing in the list?
No, my lord. 30th September is the last date. I have to comply, my lord. Otherwise, the appeal become infructuous.
You mention, give the slip, we'll list it, then let us see what happens there.
Most of
Yes.
At least
One first appeal for inclusion.
First appeal hearing.
No, my lord.
most of
It was not been heard till today. It was filed
So
in
it's
the
at the
month of-
hearing stage?
No, my lord, it is in the first stage. It was
Application. No, admission hearing is required.
No, my lord, application hearing.
Application is there.
Application
So
is
write
there.
application and mention. Say
Yes,
application.
No.
Yes.
This is the land motion.
Yes.
Item number 159 and 160. Probably this is wrongly appearing under the heading hearing. It will be under the heading application. The stay application is pending for hearing.
This will appear under the heading application then? Application.
No, I am mentioning one or 41 one application.
Yes.
My lord, I'm mentioning in respect of an appeal, my lord, this is accompanied by stay application and condemnation.
Stay application will appear. Write application and yes, stay application will be listed.
Written, my lord, I've written.
What have you written?
The condemnation application as well, my lord.
Whatever the application, write application on the top.
My
And then
May be permitted to mention one appeal, my lord. It is from appeal from a decree whereby my suit was dismissed, my lord.
appeal, no, not.
Your lordship for
Like,
inclusion.
there is also an
amendment
application
appeal,
for condonation of delay, my lord.
Application we can take up. Mention the application, right? Application.
Your lordship.
The
Yes.
written application.
It will appear.
Execution proceedings are proceeded by
It will appear in the list.
accordingly.
Your lordship for inclusion. Mandamus appeal. Mandamus appeal.
No, not right. Yes.
First appeal hearing, your lordship.
My lord, may I mention, this is the matrimonial suit. This is the first appeal is ready for hearing.
Appeal we are not.
My lord, mentioning for inclusion.
What?
For can application. You are.
Yes.
Go ahead.
Follow me.
Into that.
Give the heading properly. Application. Hearing we are not taking. Only applications.
It is for hearing of application.
Relative.
Yes, call on the list. Then.
Two applications are there, my lord. One, my lord, application for A, my lord. Another, my lord, is application for additional evidence, my lord. This is the first appeal, my lord. My lord, my letter of administration was rejected.
Why rejected?
Rejected, my lord, on the ground, my lord, that the executor has not renounced, my lord.
Has not?
Had not renounced, my lord. But
You
my
are
lord,
the
in the
legatees.
evidence,
You are the legatees.
my lord. In the evidence, my lord, the executor were examined and he said that he does not have time, so he has not applied for probate, my lord. That is there in the record, my lord.
Yes, Mr. Mathur.
And others as to the
So for the first application, this is application for stay of the operation. Well, since the probate application has been dismissed or letter of administration,
No scope of stay.
no scope of stay.
But
And second application for
Second will direct opposition to be filed and will take it up along with the appeal.
and no, my lord, the document which has been, my lord, relied upon,
Yes.
my lord, the authority who has issued this authority is not legible. দেখো এটা কি authority একটু দেখো বোঝা যাচ্ছে না কিছু। I have to search whether this document is correct or not first.
No, no, this question will be kept open.
In that
They are not
manner-
adjudicating the application. Because unless the application is allowed, they don't have a right to bring this on.
But if you also sees my stay application, my lord, in effect, my lord, it is my lord, application for injunction, my lord. If your lordship sees, my lord, my aberment made in page para 33, but it's my mistake, my lord, that prayer of injunction instead of injunction, the stay was given, my lord. But
Third party interest.
Third party interest, my lord. Para 33, my lord, that they are going to sell, my lord, the applicant stated the opposite party have after obtaining the said order of
Sir, Mahato, you are appearing only. There is only one.
one.
So we are restraining both of you from creating a third party interest. The present appeal arises out of
I shall file opposition on. Kindly make it.
to the stay application.
But I have to talk with the client.
Very the present appeal has been filed assailing the dismissal of the appellant's application for letters of administration on the ground, inter alia on the ground that the executor has not denied and not expressed unwillingness to apply for probate, which the learned counsel for the appellant submits that in the evidence from the evidence, it transpires that the executor is not willing to file a probate application due to dearth of time, and as such, the application was very much maintainable. So, next para, such contentions are controverted by learned counsel for the respondent. So, be that as it may, an arguable case has been made out. An arguable prima facie case has been made out for hearing the appeal on merits. First, since the respondent seeks to use an affidavit in opposition to the application, can one of the respondent is directed to file such opposition within a fortnight from date. Reply, if any, shall be filed within a week thereafter. First, both parties shall remain restrained by an order of injunction from selling, transferring, alienating, and/or creating any third-party interest in respect of the estate of the deceased, which is the subject matter of the proceeding, till disposal of Can 1 of 2023. Which of next para, insofar as Can 2 of 2026 is concerned, in view of the nature of the same, being that of an application for production of additional evidence, the same is required to be heard along with the appeal, subject to the maintainability of the same as well as the veracity of the documents sought to be produced, being kept open for hearing, for being argued at the final hearing. First, the respondent shall file affidavit in opposition thereto, if any, also within a fortnight. First, reply thereto shall be filed within a week thereafter. First, Can 2 of 2026 shall be listed along with the hearing of the appeal. First, Can 1 of 2023 shall next be listed on September 21, 2026. First, next para, in view of appearance of the respondent through his learned advocate, service of notice of the appeal on the respondent is dispensed with, and the appeal be treated to be ready as regards service. The trial court record shall be brought by special messenger at the cost of the appellant, to be deposited within a fortnight from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. First up, the original will, as and when the same comes to this court, shall be kept in safe custody under the aegis of the learned Registrar General. Thank you.
কালকে দিয়ে দিচ্ছি
And I beg to appear for the respondent wife.
Yes.
And I have cured the defects, and I have served the affidavit in reply. And one is for stay, my lord. They have preferred
The appeal arises against what?
against the
Grant of permanent alimony.
decree of divorce
And
permanent.
oh, you said that you want
Then the quantum of the, my lord,
alimony.
alimony. Lord,
What is
I
the
earned
amount directed by the trial court?
20 lakhs. I earn 3,000 a month.
We can consider staying, but subject to your payment of some amount.
That, my lord, I need to take instruction.
Because it's in the nature of a money degree in that sense. So ideally, we should direct you to deposit the entire amount, but this is not a money degree in that usual sense. So they have to get the benefit of your whatever we direct you to pay. You have to, because they have to subsist also. Is there any child? No.
No, there is no issue. But only one thing, my lord, they are all along defaulting. My lord would kindly take the pain of looking at my opposition at
Mr.
page.
Banerjee, the previous default you have to take out because
Yes, that we have taken out. There, no, there is an order of our court. Our court, my lord, that also he is defaulting. Your lordship
how
would,
could in this appeal?
I tell your lordship. Well, initially, my lord, I brought a suit for divorce. He instituted.
That was in correction with the Section 24 order.
No, no, no.
Our court's direction?
No, our court's direction in the previous round of litigation. I'll just. My lord, mine was suit for divorce, his was restitution of conjugal rights. My lord, initially, my lord, the suit for divorce was dismissed and restitution of conjugal rights decreed. Against that, we preferred an appeal. My lord, I brought out an additional evidence, my lord, where the husband had wrote a letter in the society where I live regarding questions regarding my character, impugning my character, my lord. That, my lord, the Honorable Court took into consideration, remanded the matter. While remanding, my lord, the Honorable High Court had directed a maintenance of rupees 10,000 to be paid per month till the disposal of the matrimonial suit. In the matrimonial suit, my lord, he did not pay the maintenance, one, and my lord, he withdrew the restitution of conjugal right. And the learned at court, my lord, took cognizance of those letters and decreed the suit on the ground of cruelty. My lord, he has accepted that decree of cruelty. On the other hand, he has accepted the restitution of conjugal rights. He has withdrawn it. Now he is challenging the quantum of maintenance.
What would be the dues on account of that?
Yes, my lord, that I have said in my affidavit.
Anything after that?
Yeah, in my affidavit in opposition, kindly takes page 5. The total due as on today is 1,49,500. Page 6, I have given the details.
In the reply, how they have dealt with this paragraph? Paragraph. Your paragraph 40. Para 9 of the reply.
Page 7, my lord, paragraph 16, my lord, deals with paragraph 6, my lord.
No, paragraph 40, they have given the chart. Let us see how you have done.
Paragraph 9. There, paragraph 9.
This is an evasive denial. You have not given anything to show, produce anything to show that you have paid more than this.
And on the earlier occasion, my lord, he had relied on an income certificate. That, my lord, the Honorable Court seriously disbelieved in page 20 of my affidavit in opposition. The order. The order of remand kindly takes page 20. And at page 21, my lord, this document.
Initially, I was.
Wait, they are arguing.
I'm sorry.
And
yes,
this is not the first time. Kindly takes the pain of looking at page 16. The husband's conduct, the learned court in 125 proceedings has held, my paragraph page 16, my lord has found, first, second, third, fourth, fifth paragraph. I find that the opposite party has not approached the court with clean hands, especially with regard to his monthly income. Now, if your lordship kindly takes the order impugned, the judgment and decree, there, my lord, the court has seriously questioned, my lord, to take the pain of looking at page 102, 112 of the stay application, how the court has dealt with it. Page 112, second paragraph. My lord has found. Second paragraph. This 10,000 order that was not assailed by him. Thereafter, my lord, kindly sees, my lord, no clarification is provided on behalf of the respondent against the submission on behalf of the petitioner to the effect that the respondent has not disclosed the source of two amounts of rupees 10,000 each, which have been credited to his bank account on 8 January 2025, and the amount of rupees 49,500. which has been credited to his bank account on 18th of January 2025, and the purpose for which an amount of rupees 35,470 was debited on 18th January 2025, and amount of 35,000 has been debited on 19th January 2025. Not only this, my lord, we had taken a categorical stand before the learned trial court that he files his income tax return. He files his income tax return and he has not produced that document. That stance we have specifically taken in our alimony application. Now he has not come with any
what does he
explanation.
do, according to you?
He is an engineer.
The engineer means he's employed somewhere, or
engineer?
63 years old.
Yes.
He is engineer and he is civil engineer, and he does, my lord, he's a contractor.
Very.
Let us kindly see the order he have relied upon in his opposition, my lord, in the 125 proceeding, my lord, where the claim was that my earning is 12,000 a month, 2050. Kindly see the order once, my lord.
It's your special knowledge. How are they supposed to know? You had to disclose, you did not.
Here also I admitted at that particular point of time in 2003, at the time of our marriage.
You said your income was 3,000 per month, which was disbelieved.
Presently, my lord, presently my income is 3,000. But the income certificate.
No, the 125 order records. It is inconceivable that a person who earns 3,000 would send 2,000 per month to the petitioner regularly. Page 16 of the opposition.
I have seen that, my lord.
Your stand before the 125 court was that you were earning only 3,000, which was disbelieved. Before this court, when it came up in the earlier round of litigation, despite getting liberty, that is the finding of the court, you failed to file any affidavit of assets.
Already.
So you are suppressing your income. And contracted, some paper was produced which was disbelieved. Why should we believe you?
Subsequently, my lord, I have filed my affidavit of assets, my lord.
Where?
Before the trial court, my lord.
Maybe. That is a subject matter of the main proceeding. But why didn't you comply with the 10,000 order? You have not challenged that?
My lord, I am earning a very limited income of
whatever.
My lord, I am.
No. We cannot grant stay. We will direct you to pay this 1,49,500, which is already due, and also a lump sum amount of rupees, at least 2 lakh rupees, which is 1/10 of this amount. 2 lakh rupees for the time being. Ad hoc payment of 2 lakh plus this within a month from date. We'll give you a month. Within 1 month, as condition for stay. You want to 2 lakh would be a little bit meager though.
But kindly,
it has to be more actually. 2 lakh is a small amount because you are challenging a direction of 20 lakh. 2 lakh would be very little.
Kindly see the consider.
We can
the
give you
capacity.
more time.
But kindly give us 2 months time, my lord, in between.
2 months time, then you have to deposit, pay this arrears plus 4 lakh then.
But kindly, my lord, don't make it 4 lakhs, my lord.
No, we'll make it 4 lakh. You are challenging a decree of 20 lakh. Ideally, in a money decree, we had to direct you to put in the entire amount as condition of stay. We are not doing that. At least 4 lakh you pay. We'll give you 2 months, but this dues 1,49,500 that has to be paid by the end of this month. We are on 19th. It has to be paid by 31st of August. That you have to pay, and another 4 lakh by the end of not 2 months actually. By the end of September, you have to pay that 4 lakh.
Kindly do not make it 4 lakhs, my lord. Kindly make it let it be.
Cannot be less. 4 lakh is only 1/5 of this 20 lakh. She has to survive also, and you have been depriving her since long. That is the only condition of stay. We'll grant stay for a period of a year. We'll direct you to on condition of these payments, and you'll be preparing the paperbooks and the trial court records. Those directions will be nothing else.
But, well, I shall.
Yes, we're doing that. For the time being, we are directing stay will be for 1 year or until further order, whichever is.
But upon payment of that amount.
Obviously. The present challenge has been preferred by the appellant husband against a judgment decreeing a suit for divorce filed by the respondent wife, as well as granting permanent alimony of ₹20 lakh. Full-stop learned counsel for the appellant, at the outset, submits on instruction that the appellant is not aggrieved by the divorce decree, but assails only the component of permanent alimony. Full-stop next para, learned counsel submits that the appellant is a senior citizen and has meager income. Full-stop as such, it is submitted that the amount directed to be paid by the trial court is exorbitant. Full-stop next para, it is further submitted that affidavit of assets of the husband was filed in the trial court, which was not adverted to properly by the learned trial judge. Full-stop next para, the present income of the appellant, it is submitted, is ₹3,000 about ₹3,000 per month. Full-stop next para, learned counsel for the respondent submits that in the earlier round of litigation, the suit filed by the appellant husband for restitution of conjugal rights was decreed, whereas the suit for divorce filed by the appellant by the respondent wife was dismissed. Full-stop, upon an appeal being preferred against the same, the matter was remanded to the trial court, upon which the appellant husband did not press further his suit for restitution of conjugal rights, whereupon the present judgment was passed. The impugned judgment was passed. Full-stop learned counsel draws the attention of the court to an order of maintenance passed on December 14, 2015.
12th of December.
Yes?
12th of December.
No, there's a correction there.
Oh, I'm sorry.
December 14, 2015, by the Judicial Magistrate, Second Court at Barashat, in a proceeding under Section 125 of the Code of Criminal Procedure, wherein the learned magistrate recorded that the husband had not approached the court with clean hands, especially with regard to his monthly income, and had not mentioned the name of the contractor under whom he was working. So it was further observed that it is inconceivable that a person who earns ₹3,000 per month only would send ₹2,000 per month to the petitioner wife regularly. Full stop. Next para. We also find from the judgment of remand in the earlier round of litigation dated November 21, 2022, passed by a coordinate bench, that the said bench had categorically recorded that the husband was paying at that juncture rupees 3,000 per month as maintenance, and considering that the wife has no independent source of income and the husband is duty bound to maintain his wife who is unemployed, comma, the directed the husband within bracket present appellant bracket closed to pay alimony pendentility at the rate of 10,000 rupees 10,000 per month on and from December 2022 till the disposal of the suit. Push up. Next para. It was further observed that the respondent husband therein, comma, in spite of liberty being given, comma, did not file an affidavit of assets and liabilities, and a document alleged to have been signed by the employer produced before the division bench in support of his present income was not accepted by the bench, as the authenticity of the said document was in doubt. Full stop. Next para. However, comma, there is no dispute to the fact that despite such direction of payment of rupees 10,000 per month during the pendency of the suit after remand, comma, only a part of the said amount was paid by the husband. Full stop. In paragraph number 4 within bracket small e of the affidavit in opposition, comma, the respondent wife has categorically alleged that the husband has not paid an amount of rupees 1,49,500, which still remains as the dues of payment of alimony as directed by the earlier coordinate bench. For sub next para, in paragraph 9 of the affidavit in reply, comma, the husband has only resorted to evasive denial in that regard and has not produced any document to substantially dispute such claim of arrears. Full stop. Next para. Thus, comma, in our opinion, comma, the husband, the appellant husband is required to be directed to immediately clear off such amount in favor of the respondent wife. Full stop. Next para. Even otherwise, comma, the nature of the decree impugned before us boils down to that of the quantum of permanent alimony, which is in the nature of a money decree. Full stop. Ideally, comma, the entire decretal amount ought to have been directed to be deposited. Full stop. However, comma, it might be premature at this stage to direct such payment without deciding the appeal on merits. Full stop. The ends of justice, comma, however, comma, would be subserved if 1/5 of the decretal amount, that is rupees 4 lakh, is paid by the appellant husband to the respondent wife on an ad hoc basis for the time being to meet the subsistence of the respondent for the present. Full stop. Next para. In such view of the matter, comma, can 1 of 2025 is disposed of by granting stay of operation of the impugned decree insofar as the payment of alimony, permanent alimony, is concerned for 1 year from date, subject to the appellant paying directly to the respondent wife an amount of rupees 1,49,500 by the end of August 31, 2026. Full stop. Subject to further payment of an ad hoc amount of rupees 4 lakh by the appellant to the respondent within September 30, 2026, comma, the stay of operation as granted above shall continue for a year from date. Full stop. However, comma, in default of payment of any of the aforesaid amounts, comma, the stay order shall stand automatically vacated and the respondent wife would be at liberty to proceed with execution of the same without further leave from the court. Full stop. Next para. All such payments shall be made at the bank account of the respondent wife. You had been paying to the bank account.
Yes.
To the bank account of the respondent wife by online transfers, comma, to which account the earlier payments were being made by the appellant all along. Full stop. Next para. in view of the appearance of the respondent through her learned advocate, service of notice of the appeal is dispensed with, and it is deemed that the appeal be treated to be ready as regards hearing. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall also prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to mention the appeal for hearing as and when the same is ready for hearing. For next para, it is made clear that the above payments shall be without prejudice to the rights of and contentions of either party at the final hearing of the appeal and be subject to the outcome of the same. প্রথমে একটা লিখে দিতে হবে affidavit reply file to be kept on.
But the appellant is the defendant.
Yeah, for the respondent.
Respondent plaintiff. Also, the suit for declaration of title, the
Your suit
is the tenant.
Your suit.
My suit. We are the defendant. But the suit is for declaration of title. That plaintiff is the tenant in respect of the civil property. Now, there are at least 27 tenants. We purchased the property. That is, the defendant purchased the property on 13th October 2018.
You are also a tenant initially?
No, we are the promoters.
All right.
The at present owners, we purchased the property for developing this.
All right.
There are 27 tenants.
Right.
26 tenants already given no objection for developing this property upon compliance of section 412A. That Lordship, the rehabilitation of the tenants. Now, Lordship, this building, Lordship, kindly come to my reply. One document I want to show that there is a notice under section 411 that the building is a dilapidated building, and already a notice under section 411 has been issued. Kindly come page 19. This notice was issued on 24th December 2021. Page 19 of my reply.
Reply কোথায়? और কাগজে করতে বেশ বলে পাঠানো হবে। দেখো অ্যাপ্লিকেশনের সঙ্গে পজিশন লিখতে হবে। Yes, page 19.
Page 19.
Yes.
Now, the concerned executive engineer wide the letter dated, this order dated and issued under section 411 of the KMC Act on 24th December 2021, directed to demolish, remove the damaged proportion of the building. Now, subsequently, Lordship, got the sanction plan, and Lordship, when we are ready to develop the property, this suit has been filed. Now, Lordship, kindly come the in order. Starts from page 46.
You are the exclusive owner of the property now?
Exclusive. As on.
Yes.
But this interim injunction till the disposal of the suit has been granted, kindly come to page 47. It is further argument on behalf of the plaintiff that if he is evicted from the suit property, there is no alternative accommodation for them where he can reside with his family. And at this stage, if without due process of law, the defendant number OP 126 forcefully evict them from the suit property, that may cause irreparable loss, injury, which cannot be compensated by money. Accordingly, plaintiff petitioner pray for absolute injunction.
Mukherjee, is there any tripartite agreement with them or between you and them, this person, regarding their shifting or something like that? Then what right do you have to evict them without due process?
Now, Lordship, first of all, this building is in dilapidated condition. We are the owner. This is our responsibility to
Repair it.
Because due to their obstruction,
Then
we
the
are
corporation will take its own, the law will take its own course. Corporation will take steps. Why are you bothered?
Now, Lordship, only one thing. This because due to this is the admitted fact, and we are giving undertaking before your Lordship.
If due to a court injunction, you cannot make any construction there, then the liability is on the court. And if you affirm it, it's on us, not on you. So you are not violating the law, the KMC law, by not demolishing or repairing.
Now, Lordship, we are giving undertaking before your Lordships that 412A, which is the provision of Lordship rehabilitation, that the argument of the plaintiff before the learned court below, that we are not taking any steps, that is we are giving undertaking that we are taking there to the shelter after the development.
Mr. Mukherjee,
Same
you cannot
portion
take the
will be-
law in your own hands. For that, there is a provision under Section 6. You have to file a suit and get an eviction for building rebuilding. You cannot just like that have force them to leave the premises. If they agree, it's fine. Give them an alternative accommodation. Give a suggestion, a proper alternative accommodation commensurate with this. Then we can consider. We can ask them to consider.
Your Lordships have sent us to the mediation. Lordship, we have tried our level best,
Failed.
everything, every possibility, but Lordship, they did not cooperate. Even last 2-3 days, they didn't appear also.
Then you have to file an eviction suit, Mr. Mukherjee, and have them.
Now, Lordship,
Without that, we cannot permit you to oust them just like that, just by citing a KMC.
No, we are not ousting. Lordship, we are developing this property. After the development, Lordship,
In between, they will not be ousted. They can stay there, sit tightly, live there, and you will develop around them.
No, Lordship, we are accommodating them in another place. In terms of that is the provision
That
of
is
law.
what we are saying. Give a specific proposal in writing. That place has to be, the costs have to be borne by you, maybe adjusted from the rent.
Yes.
Because they are liable to pay rent to you.
Kindly come to them our Lordship, the written argument. We have filed before the learned court.
Written argument does not have the force of an affidavit.
No, Lordship, we have also filed the
What are
written
you agreeable
objection.
to? They have to be satisfied that the other accommodation which you are giving them, that is commensurate with the present accommodation. You cannot just push them, shove them in some.
Lordship, we have provided them that these are the Lordship place. We are trying to rehabilitate them.
Where is that?
Lordship, kindly come.
Page
that is the page 30
of the state.
Of the Lordship.
37, yes. Will rehabilitate all the.
It is agreed that the defendants will.
No, we want a specific offer. Not will rehabilitate, will not do.
So we will.
Specific offer where you have to show them the flat. If they agree, then we'll direct them to shift.
Yes, so kindly give me a time within the certain time. Also, we will Lordship, provide all these particulars where we will.
Yes.
Lord, this is coming when they have been cornered, my lord. They committed produced forged document before the corporation to obtain the plan. My forged document, I have filed an FIR, my lord.
They have produced a document where you have signed.
No, it was forged document.
No, that document shows that you have signed, but you have not signed.
Yes, and the hearing took place. Thereafter, we lodged the complaint with the police. Police has lodged an FIR, my lord. On that basis, they obtained the plan.
We have
lot of water has flown down. My lord. Now,
That was disclosed in your objection, written objection
Yes,
in
my
trial
lord.
court.
Yes, for the trial court, before this court also, my lord.
Complaint disclosed court.
This page 14.
No, my lord.
You are Abdul Jabbar.
Abdul Jabbar is my father. My lord.
So there's
Was
a
my father.
letter written by Abdul Jabbar apparently at page 14 in Hindi.
I was tenant in respect. My father was a tenant in respect of 2 rooms.
Right.
Lord, after death of my father, after I became the tenant, my lord. They forcefully occupied one of the room. B5 they forcefully occupied. For that we have filed another suit against that trespasser. That is also pending.
No, but where is the police complaint? In your opposition, where have you disclosed that?
And I have written in on affidavit, my lord. Police complaint I have brought.
There is no annexure.
You have
But
written,
the
written in your opposition, you have written. Where is that?
Yes.
Where is that?
This is the FIR, my lord.
No, we can't look into documents which are not there. You got your opportunity to file opposition. Wherever you stated show us that will suffice. Or you have denied your this signature and all. In your opposition, it has to be there.
Yes, yes.
Can't look into documents just like that. So Mukherjee, if there is no scope of
Lordship, may I clarify the
Paragraph
situation?
9.
Lordship, when we have got the sanction plan, Lordship, they have challenged the sanction plan before the Honorable Lordship, the Reed Court, before the Honorable
your
Single
sanction plan does not entitle, even if it is valid,
that is correct.
does not entitle you to evict a tenant. That's between you
Lordship,
and the
this is
corporation.
the-
Corporation finds that there is a valid sanction.
Lord, paragraph 11, my lord, at page 7.
So you have challenged the that sanction plan also.
Yes, I have also challenged.
What happened in the writ court?
No, the writ court, my lord, writ court dismissed, then we went to the appeal court, my lord. Appeal court said corporation will hear out the matter.
That hearing is going on.
That hearing has concluded, my lord. On the basis of that, we have filed the FIR.
No, corporation has not
An
taken
order
a-
has been passed till date.
No order has been passed
No
by the
order.
court.
But documents were produced on the basis of that, we have lodged the FIR. Not paragraph 11, my lord. I state that the appellant mischievously and surreptitiously applied for sanction of building plan before Kolkata Municipal Corporation under Rule 142 of the KMC building rules without my knowledge and consent and submitted fabricated
You have not
documents
stated that
containing
the
my
legal recourse.
forged signature. In this situation, I was not left with
So
other.
therefore, you have not lodged any complaint. No complaint is referred to even again.
No, complaint I have lodged, my lord.
Should have referred that in your opposition. Anyway, so you are disputing that signature first of all.
Yes.
Secondly, on that ground, now a hearing has been concluded before the KMC.
But no order has been passed.
No order has been passed. So are you agreeable if they give you a proper accommodation? Are you agreeable to shift there?
No, I have
Because
suffered
for
a
you
lot.
only this is stalled. They have a sanction plan, balance of convenience. We also have to consider.
No,
We are not saying we cannot force you to leave. You are otherwise entitled.
Not in matter went
Let
to
us be pragmatic also.
matter went to mediation, my lord. In mediation was unsuccessful.
You, Mr. Samarwala, you personally intervene and see whether your client is agreeable. If it's a sum of money or it's an accommodation with the undertaking by them to that they because see 26 have already given their sanction plan will lapse. No useful purpose will be served.
Not
The building is
my lord,
dilapidated.
a developer cannot obtain a sanction plan and then ask the tenant to.
It's not a matter of ego. It's a matter of pragmatic reality also. They have obtained a sanction plan. The building is
From the-
dilapidated.
from the
There's a notice of the corporation also. Tomorrow, if
But
the
the
case-
notice says, my lord, you demolish the dangerous portion.
that is the
and-
usual notice.
and
You
sir-
demolish, otherwise I will demolish. That is the
No,
law.
no, sir. It says that you salvage the good portion and damage the dangerous portion.
If you are in the dangerous portion, then what happens?
I am not, but I have written that my portion is okay.
So very well, we'll leave you to the vagaries of the corporation then. We'll say that this injunction will not prevent the corporation from taking steps for demolition if it is found that it's illegal in the illegal. We'll clarify that much. Yes, Mr. Mukherjee, we cannot do more than that. And we'll also modify the order to the extent that you will not be able to evict them without due process of law. We'll incorporate that. Resort to due process of law and evict them?
Lordship,
But there's a specific ground under the Premises Act for building rebuilding. We cannot permit you to just like that throw them out. They're entitled to injunction otherwise. Their tenancy is admitted. So you cannot just oust them like that. If they don't want, we cannot force them.
kindly see the plaint they have filed in 2015. The same identical property. Lordship, they are also claiming the recovery of possession from the another person.
Trespasser.
Trespassers.
Separate rule.
And Lordship, they are also claiming that they are the tenant in respect of B5 and B6, 2 rooms. Whether in the respect of present plaint, they are claiming B6.
Whatever is the subject matter of this suit, they are entitled to an injunction regarding that because they've produced rent receipts regarding this part of the property only.
And Lordship, kindly see the mediation.
They have produced rent receipts. They have
Lordship,
produced
we
rent
have submitted before the mediator that these are the
We cannot
benefits
take into
we are
documents.
ready to, also willing to offer them.
that offer they're not accepting what we cannot force them. We can only modify the order to the extent that this will not prevent you from taking recourse to law for evicting them. Secondly, this will not protect them from any action which may be taken in accordance with law by the KMC.
Also kindly direct the learned court
Dispose
below
of
to
the appeal
dispose
with
of
that.
the
Injunction remains. This will be subject to the rider. Without due process of law, they cannot evict you. One. Secondly, this will not per se, this order will not protect you from any action which may be taken in accordance with law by the claims.
Right.
And you will be entitled to take your remedy against that.
Also kindly direct the learned court below to dispose of the suit
Within a week?
3 months.
Within a week?
Already date of issue has been cleared. 3 months.
What is the year?
We are suffering
No, my lord.
26
Can you
tenants.
give an early
we are
date? We
ready-
want this suit to
No,
go.
no, you are
reply.
very happy to have an early date, both of you, but the court will not be very happy. Are we happy when Supreme Court directs us?
Because in the trial, everything will come out. What they have done.
Lordship,
We appreciate your
26
confidence.
tenants, Lordship,
But
entire
we
cost,
appreciate your
Lordship, we are
confidence, but we
ready-
cannot be
regularly board.
cruel on the learned. When was the suit filed?
2023.
Well, we can express a hope.
Because
regarding-
26 tenants, Lordship, we have to have given the rehabilitation, Lordship, entire cost.
In view of the short conspectus of the appeal, we take up this, we admit the same and take, it was admitted already. Must have been admitted. If it,
Yes.
In view of the short conspectus of the appeal, comma, the same is taken up for hearing along with the application. Okay. Full stop. Next para. By the impugned order, comma, in a suit for declaration of tenancy rights and consequential reliefs filed by the plaintiff stroke respondents, plaintiff stroke respondent, comma, the learned trial judge granted injunction restraining, directed status quo to be maintained by the parties in respect of Schedule B property till disposal of the suit. For sub next para, learned counsel appearing for the defendants stroke appellants argues that the appellants have purchased the property and are the exclusive owners thereof. Full stop. It is submitted that altogether there are 27 tenants in the said building, out of whom 26 have agreed to shift from the premises in order to enable development work and a new building to be constructed on the property. Full stop. However, comma, due to the resistance of the plaintiff stroke respondent, comma, who is also a tenant in the said building, comma, such development work cannot be undertaken despite the appellants being armed with a valid sanction plan. For some next para, secondly, comma, it is argued that the Kolkata Municipal Corporation has already issued a notice under section 411 of the Kolkata Municipal Corporation Act asking for appropriate steps to be taken, comma, as a prelude to demolishing the premises on the ground that the same is a dilapidated one. Full stop. Next para, learned counsel further submits that the appellant is agreeable to provide an alternative accommodation to the respondent till the development work is done, and thereafter to rehabilitate the plaintiff stroke respondent appropriately. Who sub next para, learned counsel for the plaintiff respondent submits that the respondent has preferred a challenge against the sanction plan obtained by the appellants, which was allegedly obtained by forgery. Full stop. It is submitted that the signature of the plaintiff stroke respondent was manufactured and forged in a document submitted by the appellants before the Kolkata Municipal Corporation for obtaining the sanction. Full stop. As such, comma, such sanction is vitiated. Full stop. It is further submitted that the plaintiff stroke respondent has already lodged a complaint before the police in that regard. Full stop. Even otherwise, comma, the plaintiff respondent had preferred a writ petition challenging the sanction plan, which was ultimately disposed of by directing the Kolkata Municipal Corporation to give a hearing to both parties. Full stop. Such hearing has already been concluded, but no order has yet been passed thereon. Full stop. Next para. Thus, comma, it is argued that the learned trial judge was justified in observing that evidence is required to be laid for coming to a conclusive finding as to the legality of the possession of the appellant respondent as well as the right of the appellants with regard to the property. So next para, upon a careful perusal of the impugned order, comma, we find that, comma, otherwise, comma, the appellant, the respondent has prima facie proved that he is a tenant in respect of the subject property and as such is entitled to have an injunction protecting his possession unless otherwise evicted by due process of law. Full stop. However, two vital aspects have not been adverted to while passing the impugned order. Full stop. First, in view of there being a pending dispute before the Kolkata Municipal Corporation in the light of a demolition notice issued by the corporation, and since the corporation has already concluded hearing the parties on such aspect of the matter, the impugned order cannot be used as a shield by the plaintiff stroke respondent to seek protection against lawful action which might be taken by the KMC in the event it is ultimately found out that the portion of the suit property occupied by the plaintiff stroke respondent falls within the dilapidated stroke dangerous portions of the building. Full stop. Next para. Secondly, nothing prevents the plaintiff's the defendant stroke appellants from taking due legal action for evicting the plaintiff stroke respondent, if the appellants are otherwise so entitled in law. Full stop. Next para. Accordingly, FMAT 162 of 2025 is disposed of by modifying the impugned order bearing order number 15 dated April 1, 2025, passed by the learned judge, 6th bench City Civil Court at Calcutta, entitled suit number 2460 of 2023, to the extent that the status quo order granted by the learned trial judge shall operate but be subject to the riders that nothing in the said order shall prevent the Kolkata Municipal Corporation from taking any action, if otherwise permissible in law, in respect of the suit property, in terms of the provisions of the Kolkata Municipal Corporation Act and or otherwise in accordance with law. Secondly, the appellants shall be at the defendant's appellants shall be at liberty to obtain an eviction of the plaintiff stroke respondent, if so otherwise entitled in law, in due process of law, and nothing in the impugned order of status quo shall prevent the appellants from taking recourse to such due process of law for the eviction of the plaintiff stroke respondent. Full stop. With the above observations, we express hope and trust that the learned trial judge shall decide the suit, which is pending since the year 2023, as expeditiously as possible, preferably within 1 year from the date of communication of this order to the learned trial court. Full stop. Can 1 of 2025 stands disposed of accordingly as well. No rest costs are decided.
Lordship, only one Lordship rider that 26 tenants who have came to a development agreement with us. We have given them rehabilitated place. Only this.
We need not go into that. If you record that in subsequently it is found out that you have not, then they have a new cause of action and your litigation will be multiplied. Let us not record something beyond the scope of this. Their plight is not our consideration in this appeal. We are only considering his right. And we have qualified that status quo, yes, and we have passed forward.
And appeal and the application disposed.
Appeal and application both. Appeal, in the first sentence we said when we started the and application.
Yes.
Thank you.
Item number 4.
Plus, I am for the appellant.
Yes, yes.
My application for stay of the judgment and decree. Plus, this is that suit judgment and decree passed under
That's
section.
good. We have been taking up
Because your lordship already heard this appeal. Yes, that's to refresh your lordship memory. This suit has been filed under section 2G. Yes, I have started with the plaint. If your lordship kindly comes to the plaint first. But I will just refresh your lordship memory and cite few judgments. That's all.
So 2G eviction.
Yes. Kindly comes to
Yes, sorry.
Page 11 of the Muller's
Stay.
application, yes.
Yes. Yes.
Malas, it is Malas, only Malas, if your lordship kindly sees in the cause title, only Malas, Ashok Jaiswal Malas has been impleaded as the defendant. Now, Malas, in paragraph 1, Malas, they have said one Madhuri Jaiswal was the Malas recorded tenant. And Malas, date of death has not been given. Malas, in paragraph 1.
Oh, yes.
Paragraph 1, Malas, they
Madhuri
have
Jaiswal,
said
right.
Malas, Madhuri Jaiswal was a recorded tenant in the subject premises. Paragraph 2, Malas, they have directly said that Madhuri Jaiswal died and after her demise, tenancy held by her has been extinguished under the provisions of section 2G. Malas, thereafter, if your lordship sees paragraph 3 onwards, Malas, they have just said, Malas, they have requested the said defendants to Malas vacate the premises. They, as he has not done that, Malas, they have sent a notice. Malas, that has also not been complied.
How are you related to Madhuri Jaiswal?
Malas, I am the spouse.
Spouse.
Malas, except that nothing has been pleaded in the plaint. Malas, that is my first ground, and that Malas, for spouse, there is a life estate. So, Malas, the cause of action, Malas, if they say,
Yes.
if they say, Malas,
Spouse life estate.
yes.
Provided the spouse
Yes,
resides
Malas,
and
three
was
conditions has to be satisfied. That
dependent and
he has to be resided with the tenant at the time of his death, and he has no other premises for his own. Malas, he should not own or occupy any other premises, and should be dependent upon the spouse. The three conditions has to be fulfilled. Malas, I will show that also. So, Malas, in the plaint, Malas, to show that they have the cause of action to Malas file this suit, Malas, they have not pleaded anything except the this point of law that the Malas tenancy has been extinguished.
what should have been pleaded according to you? What has been
Malas,
omitted?
Malas, the three grounds, Malas, that has to be satisfied.
One is dependent. Second is living with the tenant at the time
Time of his
demise.
death.
Third is
Malas, the person should not own or occupy any other residential accommodation. Because Malas, they have Malas tried to take up this point in their evidence. So Malas, they should have Malas pleaded this. Because if they should not have pleaded this, Malas, I will not get any opportunity in the written statement to Malas controvert this. Malas, my natural justice will be violated. And Malas, I will show one judgment also in regard to that. So this is the Malas first point.
Yes.
Malas, may I Malas show the judgments and thereafter?
Better. One point is covered, then you go to the next.
This is 1977 1 SCC 511. Yes.
Yes.
This paragraph 41.
Yes.
This is regarding an election petition, but the provisions of CPC has been cited. That is why, like
Those
the
are applicable in election petition.
yes, like the Code of Civil Procedure, this section also envisages a distinction between material facts and material particulars. Clause A of Section 1 corresponds to Order 6, Rule 2, while Clause B is analogous to Order 6, Rule 4 and 6 of the Code. The distinction between material facts and material particulars is important because different consequences may follow from a deficiency of such facts or particulars in the pleading. Failure to plead even a single material fact leads to an incomplete cause of action, and incomplete allegations of such a charge are liable to be struck off under Order 6 to 16. Code of Civil Procedure. If the petition is based solely on the allegations which suffer from lack of material facts, the petition is liable to be summarily rejected for want of a cause of action.
Yes.
Yes, ma'am. if the petition is based solely on those allegations which suffer from lack of material facts, the petition is liable to be summarily rejected for want of a cause of action. In the case of a petition suffering from a deficiency of material particulars, the court has a discretion to allow the petitioner to supply the required particulars even after the expiry of limitation. That is for material particulars. Now 42. All the primary facts which must be proved at the trial by a party to establish the existence of a cause of action or its defense are material facts. In the context of a charge, it is regarding the election petitions that needs not be cited. And paragraph 44. The distinction between material facts and material particulars was pointed out by this court in several cases, 3 of which have been cited at the bar. It is not necessary to refer all of them. Therefore, it is therefore vital that the oral practices charged against the respondent should be in a full and complete statement of material facts to clothe the petitioner with a complete cause of action and to give an equal and full opportunity to the respondent to meet the case and to defend the charges. Merely alleging that the respondent obtained or procured or attempted to obtain or procure assistance are extracting words from the statute which will have no meaning unless and until facts are stated to show that assistance is and how the prospect of the election is furthered by such assistance. So that's relevant for this. Now, in the evidence, it has come out from the statement of the PW1. Plus, the evidence has also been given to your lordship by my learned friend.
Yes.
Plus, in the evidence,
Wait. Did you return it to UNICEF Virtual or you kept it?
I give 2 copies.
You had kept it.
Yeah.
Acha ওখানে? Annex করো? Or the bunch? দুটো bunch ছিল কি দেখতে পাচ্ছি? দুটো bunch আছে? Examination chief. Active bunch. Page.
3 conditions are required to be satisfied.
Yes, my lord.
That is required to be dependent.
That is what my case is, my lord. The 3 conditions which they are saying in the evidence that has not been satisfied by me. That is why the tenancy under section 2G has been extinguished, has not been pleaded by them in the plaint itself.
What was your evidence?
Yes, my lord.
Regarding these 3 conditions, what are the 3 conditions? You are required
the 3 conditions they tried to meet by cross-examining me, and the answers that
section 2G first.
Yes.
Please read.
Yeah. Tenant means any person by whom or on whose account or behalf the rent of any premises is or but for a special contract would be payable, and includes any person continuing in possession after termination of his tenancy, and in the event of death of any tenant also includes for a period not exceeding 5 years from the date of death of such tenant or from date of coming into force of this act, whichever is latter, his spouse, son, daughter, parent, and the widow of his predeceased son who are ordinarily living with the tenant up to the date of the death of the tenant as the members of his family. That is the condition 1, and were dependent on him, condition 2, and who do not occupy or own or occupy any residential premises. That is 3. And in respect of premises, rate of love for non-residence purpose, this is not necessary.
Yes, what else?
And the second proviso is for life for estate of the house. In the evidence, the PW1 admitted that the tenant at the time of her death was residing with the daughter. The trial court proceeded on the
Chief. এভিডেন্সে বলেছে ফ্যাক্ট দ্যাট আই ডু ওরাল এভিডেন্সে বলেছে করবোরেট করে ছিল তাই দেখেছি হ্যাঁ দেখেছি দেন কিন্তু অ্যাডমিটও করেছে ওই এখানটার সেকেন্ড ফ্যাক্টর হাউ অ্যাডমিট করেছে yes who have had
in the
what did they admit
in the they admitted that I was the tenant at the time of her death was residing with the daughter. That is also
what did they admit
in the cross examination.
their cross examination
Yes, that has also been referred to in the judgment itself. Your lordship can take
they
it from the
admitted what
that the tenant, the original tenant Madhuri Jaiswal, at the time of her death was residing with her daughter.
Yes.
And the trial court proceeded on the footing that the dependent, that is Ashok Jaiswal, the spouse, was not residing with her at the time of her death.
Yes.
Yes. So my point is,
but
one,
you say admitted that she was with her daughter. Daughter is not a party here.
yes, that is what my point is. If there specific case is that the daughter was living with her at the time of her death, the daughter should be implicated as a party. Because as I have just finished reading section 2G. 2G, if your lordship sees, the daughter is also mentioned. So daughter is also an independent right.
All right.
And they cannot.
Did you make out any case that daughter has an independent right and all these things?
It is at
you take this point in the trial court, the non-implement of the daughter.
Yes, that is in the written statement. That non-joinder of necessary parties is in the written statement, although not happily drafted. But
need not be happily drafted, but it did not.
The trial court also considered that.
Yes.
It was cited as a witness.
Page number 45. Sorry,
internal
page 23 of the judgment and decree. Kindly see page number
5 years have elapsed.
Yes, 5 years.
5 years.
Then I will become a trespasser.
When did the lady die, Madhuri?
2019.
Suit filed on
2022.
Why now it has elapsed? The daughter does not come forward.
At best, I will become a trespasser during the pendency of the suit. But if I have not been impleaded as a party,
not you.
I am not. The daughter is not impleaded as a party. He cannot be evicted. She cannot be evicted. The decree is ineffective.
Understood. Even if she has become a trespasser, he has to obtain an eviction decree.
Yes, that is what my point is.
All right.
For non-joinder of a necessary party, the suit has to be dismissed. On that point, I have one judgment. Give me a minute. Kindly. Paragraph 17. 2022 SCC online. SC 1302. Paragraph 17.
necessary party.
This court in the case of Mumbai International Airport Private Limited has observed that a necessary party is a person.
For that, a judgment is necessary. Necessary party, if not implemented, then
it is settled principle of that is
not set. The law is there.
Yes.
Definitely, if necessary party is not implemented, So it has to be dismissed for non-joinder. Non-joinder dismissal, misjoinder, no, not dismissal.
So, Manoj, I'm not placing this. The paragraph 17 I am relying on.
Paragraph
17.
17, yes.
17 and 18.
Yes, 18.
And Manoj, now in the evidence, Manoj. And another thing, Manoj, before Manoj going to their points which they have taken in the evidence, Manoj, I have exhibited. The trial court has said, Manoj, I have not exhibited any documents to show that I was residing at the time of Manoj's death of the tenant.
Other
The
card was
defendant,
produced.
the
Aadhaar
present
card.
defendant.
Aadhaar card.
Yes, Manoj, Aadhaar card and the electricity bill, Manoj, I have exhibited in the trial.
In your
Second-
evidence, you admit that apart from Aadhaar card, every other document shows you reside at 9 Belilias.
Yes, Manoj, I will come to that also. Manoj, I will also come to that. Manoj, but before that, Manoj, I have Manoj exhibited a rent receipt issued by the plaintiff. And Manoj, thereafter the rent control challan.
In your name, rent receipt?
Yes, Manoj, in the name of Manoj, the defendant, the spouse, the son and daughter.
Your name was also specifically
Yes.
mentioned there.
Yes, that has been exhibited. Manoj, the trial court said, Manoj, that the period which has been mentioned in the Manoj, the rent receipt I have exhibited has also been mentioned in the Manoj, some of the Manoj month has also been mentioned in the rent receipt exhibited by them. So Manoj, my rent receipt is Manoj, is suspicious.
We don't understand. Please repeat.
Manoj, the rent receipt I have exhibited in the
You
trial.
exhibited one rent receipt?
One rent receipt of Manoj 6 to 7 months jointly.
Oh, yes, yes.
Jointly, and Manoj, some of the months are also Manoj mentioned in the rent receipt exhibited by them.
Which was not in the name of all of you.
Not is
The
in the
different
name of Madhuri Jaswal, the original rent. So Manoj, the trial court said this is suspicious. Only that. And Manoj, my point is the rent control challan has also been Manoj exhibited before the trial.
Rent control challan is a unilateral deposit.
Yes, Manoj, but if your lordship kindly comes to section 21 of the Manoj tenancy here.
Section 21 is. Section 21, why do you rely on that? What does
Manoj,
it
I am saying Manoj, this is an independent statutory proceedings. And Manoj,
Section 21 is not a conclusive determination of tenancy.
Manoj, not. I am not saying that. Manoj, but the rent receipt I have produced has also been produced by the Manoj statutory authority. On the basis of that, Manoj, I have been allowed Manoj deposit rent. Manoj,
Yes, but that does not conclusively determine your tenancy.
Manoj, but that has to be challenged before this court.
Need not be. That is
But-
not a conclusive proof. Why should it be challenged by anybody?
Manoj, the trial court cannot merely say Manoj, this is suspicious that then I will not Manoj look into it. That is what Manoj, my point is. That if Manoj is statutory competent statutory authority, Manoj, on the basis of that, upon issuing notice to the Manoj's petitioner and the knowledge of the petitioner, and there is a Manoj, there is also a provision for Manoj, if it has been Manoj submitted, the rent has been submitted before the rent controller, suppressing material fact, they can also Manoj have the right to Manoj challenge the same before the rent controller. They have not challenged it. Under section 22, they can challenge it. They can not challenge it. Even after Manoj, I have Manoj exhibited it. And Manoj also Manoj, section 21(7) also says Manoj notice has to be issued before Manoj, I have been allowed to Manoj submit rent before the rent control. Manoj, they have not challenged the Manoj deposit of rent and the proceeding for deposit of rent before the rent controller. So Manoj, when I have submitted the rent receipt and also the rent control challan, Manoj, the trial court cannot merely say that the rent receipt is not Manoj, is only suspicious. That is why I will not look into it. That is the third point.
Yes.
And now, Manoj, the three conditions of section 2G. Manoj, on the last occasion, my learned friend has told Manoj the examination and cross-examination of Ashok Jaiswal, the Malas present defendant. Malas, my learned friend has pointed out, Malas, the examination that has been made on 7th of November 2024. Malas, kindly see, Malas, at the first, in these Malas, it is recorded of the Malas.
Yes.
The details of the witness is recorded. Your lordship kindly see at the last, occupation unemployed.
Yes.
Yes, I'm smiling. That is why. Thereafter, in cross-examination, the very first sentence that it is a fact that I do business.
I have it underlined in red, black, different color.
They are relying on that. I will also show that. I have some different points on that. And
with this sort of a cross-examination, you don't require another side. You told the truth. This is the only place where you told the truth.
I am only saying, this is
cross-examination.
I am only saying, this is not the truth. The upper portion, where the details
That
of
is the
the
truth.
that is specifically recorded by occupation unemployed.
But what about the first line in cross-examination?
What is the purpose of cross-examination?
I have that is why I want to show when the
what is the purpose of cross-examination?
Obviously to yes. But when the court asked me about my occupation, this is unemployed what has been told.
We are listening to you for so long because of your valiant effort. You are really trying well, and this probably we could not have developed so many points out of this.
Thereafter also, from my cross-examination, they have raised 3 points. One is, I am not dependent because I do business.
All the factors.
Yes.
All
the
yes.
conditions. 2, I have alternative accommodation. 2 and 3, and I will not say they are able to prove it that I was not deciding at the time of her death, because they have not made out such case in the plaint. Because if I was not residing at the time of their death, they should have pleaded that after the date I have entered into the premises. They have not pleaded that. So I am not going into that. The trial court entirely proceeded on that footing. The trial court's judgment is itself passed on that point. Now, the 2 points. I have tried to find out judgments. I was not able to find out any judgments on that. But
on what?
The question of dependency and alternative accommodation. That what could be the interpretation of that term. But in the book of SP Sengupta, West Bengal Premises Tenancy Act. Kindly see, this is page number 190. No judgments. No judgments has been cited, but the opinion of the author has been expressed. That is what I want to show to a lordship. Kindly see, the 4th condition has been mentioned, and thereafter,
yes.
Kindly come to 191, page number 191,
Yes.
The paragraph starting with different expressions used in clause G are likely to invite complications. The first condition is that the person claiming benefit of statutory tenancy is that he was ordinarily living with the deceased tenant up to his death. The word ordinarily clearly signifies that permanent living with the tenant up to the date of the tenant is not necessary. For example, the son of the tenant in connection with his service or business temporarily had to live elsewhere, but that would not disentitle him from claiming the statutory tenancy. Under such circumstances, he will be deemed to have satisfied the first condition. But a son or any of the persons enumerated in clause H of section 2 is not entitled to claim the benefit in spite of residing in the tenanted premises if it is found that he was living separately and not as a member of the tenant's family. On this ground, married daughters of the tenant will be excluded. That is what I want to show. The expression ordinarily has been interpreted that not necessarily permanently. And thereafter dependency. The last paragraph on the same page. 191. The next requirement is that the person claiming the benefit must be dependent on the deceased tenant. Nothing is more difficult than to determine whether a person is dependent or not on another. There may not be any difficulty where the persons claiming the benefit are the minor children or housewife. But what would happen where the tenant being old and infirm or for any other
Mentally
reason?
dependent.
Yes, ma'am.
Mentally dependent also comes in.
Yes, ma'am. That is right. That is why I understood. Ma'am, kindly see. Must kindly see. Or for any other reason was unable to maintain.
I have mental dependence on my wife. That's why I have to be independent.
Kindly, this paragraph kindly.
Interesting. Opinion is interesting.
And Manas was himself financially dependent on others. In strict legislative view is taken, then under such circumstances, none would be entitled to claim the benefit of statutory tenancy for 5 years. This seems to be denial of a benefit arbitrarily. The word dependent in the legal parlance means deriving existence, support, or direction from another. And the word dependence means a state of looking to another for support, maintenance, food, clothing, comfort, and protection of a home and care. Black's Law Dictionary. One who gets protection from of a home as such can also be considered as a dependent of the person who gives him such protection. Thus, the earning members of the deceased tenant's family can be treated as dependent even without getting any financial help from the deceased. If dependency is construed in this way, then it would be easier to solve many problems. For example, the tenancy stood in the name of a housewife having no independent income, or it might be that while taking the tenancy, she had some income of her own, but later on she became solely dependent on her husband. She died leaving her husband. The husband, while claiming the benefit, may argue that his wife gave him protection of a home and as such, he can very well be considered as his wife's dependent within the meaning of clause 2G.
It was a moment of inspiration for the author.
And Manoj,
we appreciate that, but
and
we're not inspired too much for it.
And Manoj, thereafter,
mental dependence on the wife is therefore he'll be a dependent.
Manoj, because if the Manoj, dependent, the Manoj tenant, the legal
is it a matrimonial
spouse?
In the same book, the divorce laws and tenancy was covered.
Manoj, even in Manoj divorce, like your lordship sees Manoj.
Even if divorce means, what is the nexus between these two?
No, Manoj, I am only saying Manoj.
You are divorced from the premises.
The maintenance provisions are Manoj gender neutral.
We are not about gender. Not at all about gender. The husband may be financially dependent on the wife also.
Yes, Manoj.
Although we are not saying that dependent means dependent under the Hindu Succession Act.
Yes.
No, we are not saying that. Dependent means physically dependent. Financially dependent. Physically, mentally dependent is I cannot live without you. That's why I am entitled to be. That would be absurd.
A
bit absurd.
The Manoj author tried to Manoj say that
no, every spouse would be fully dependent on the other after her demise for coming within the protection of this statute.
Manoj, that is
everybody
why
would claim I was dependent on my spouse.
Manoj, that is why Manoj,
and you remember that after her death.
Yes, Manoj, the author tried that.
You are not living with her during your lifetime in your case.
Yes, Manoj.
What
is my case?
Admitted that you were all your other documents are regarding 9 Belilius Road. Only one Aadhaar card and electricity bill. Apart from that, everything is different premises.
The other documents, Manoj, that is coming out from the cross examination.
Your cross, yes.
Yes, Manoj.
Cross examination, the purpose of that is there. In the death certificate, it's also there, right?
Manoj, the death certificate, Manoj, that is why, Manoj.
You have produced the death certificate of your wife?
Yes, Manoj, that is why.
There,
Manoj,
your
permanent
address elsewhere.
Permanent address has been shown as Manoj 9 Belilius. Manoj, that is what Manoj's point is, that first it should be pleaded in the place. That is why Manoj, I will give a Manoj chance to Manoj plead. And Manoj, secondly, Manoj, I have also showed that the term ordinarily has been interpreted how by the author.
Yes, it's clear.
And Manoj, third also is Manoj, that if I was not residing at the time of Manoj, the death of the wife, they should not have implicated me in such a way. They should have said that after the death of the tenant, this person has entered into the premises.
On the date of the suit, they say that you are in occupation. On the date of the suit, that's why the eviction suit was filed against you. Please go away.
Manoj, then that should be filed against the daughter because the daughter was living with her.
Don't expose the cause of the daughter. She has not come out.
Yes, Manoj, that,
evidence here.
Manoj, that has to be implemented. She has to be implemented. That is what my case is, Manoj.
Daughter adduced evidence here.
She adduced evidence.
What did she say?
Admitted. Manoj admitted that she was residing with the Manoj, the Manoj tenant along with the Manoj The spouse and the son.
And you, all of you.
Spouse and the son.
Spouse means you.
Yes. And there is son as well.
The daughter's evidence was also overlooked. That is also your.
Yes.
You're not very keen on that. Why daughter has said something against you?
No, no, no. Manas, your lordship can kindly comes to that.
Let us come to that.
Para 13 of the affidavit in chief. Para
Yes,
13.
Yes, para 13 I'm also relying upon. I submit that my mother Madhuri Jaiswal was the tenant in respect
Wait,
to
wait,
the
I've lost that. Lost that. Where is that? Near the end.
Yes, yes. It should be at the end.
Okay.
Affidavit in chief of the Malas daughter.
Yes, yes. Para
13.
1-3.
He died on 19 and the next 5 years from the date of her death, my father, myself and my brother are eligible to possess the tenancy right till 19th August 2024, but the defendant initiated this suit being, that is what, even if your lordship takes this, this will, she will become trespasser. After that, after expiry of 5 years, she's, even if this decree is passed, if she is not implemented as a party, how she can be evicted from the premises.
What is the address of the suit premises?
7A Vaishnav Shanmilani.
তাই বলতেছি পারমিট করেছে Yes.
And the last point is that since the point has been taken that I have alternative accommodation, the copy of the book that I have been handed over to your lordship, that portion of the section 2G has been interpreted with section 61D of the West Bengal Premises Tenancy Act. That is, the person should not have an alternative accommodation within the 10 kilometers of the tenanted premises.
Landlord.
Section 61D, that is the grounds of reasonable requirement.
Landlord, for the landlord.
That is not there in 2G. 2G is unqualified and who do not own or occupy any residential premises.
Yes, that
he does not have that. 6 has that.
61D has that.
Yes.
How 6 is attracted here? That is what I am saying, in the portion of the book that has been
in this book where
yes,
this the dependent book.
Yes, the section 2G has been interpreted in conjunction with section 61. That the person has not any alternative accommodation within the 10 years, 10 kilometers of the.
So we have to read 61D into 2G. Where it is not there in the statute.
Taking benefit of Howrah Municipal Corporation.
That what has been done in the book.
Different municipal corporation.
Where is the cover page of this book? Where is the cover page of this? We have just.
I can produce the entire book. This is the book of Sen Gupta. Sen Gupta's.
Yes, we want to see that. We want to give the reference in our judgment.
Yes, this is the 5th edition.
That book, but we want to see that and the edition and everything.
5th edition, it is written in the that portion itself.
Where is it?
Page 193 at the bottom. 5th edition. of Justice Sengupta's Justice or
Sushant Sengupta. What was it?
SP Sengupta.
Ancient's book is 56.
I remember only Sengupta's.
Yes, Manoj, that is the book.
Shen's book is 56.
No, the
That-
book
No,
we want to read
Sengupta.
the book.
Manoj, I can take that from the bar library. If your lordship
Take
to
from the
like.
library and give
Yes,
it.
Manoj, I'm
What is the full name of the book?
SP Sengupta, West Bengal Premium Resistance Act 1990.
Whenever you cite up the excerpts of a book, you also give us the cover
Manoj,
page.
the book is itself a very Manoj,
Dilapidated condition.
no, it's still very Manoj. What Manoj, this is a very,
Demand, high demand.
no, Manoj, this is the book is very bulky.
Has to be in high demand. SP Sengupta's premises and
West Bengal Premium Resistance Act 1997.
Publisher?
Common laws.
ইউনিভার্সিটি কমন কমনের ভিতরে এমন অনেক কিছু পাবি যেটা আমার হয়েছে আমি জাজমেন্ট সাইড করেছি সাইড করেছি জাজমেন্ট কমনে সেটা নেই আর্গুমেন্ট চেঞ্জ করতে হচ্ছে রানিং
Manoj, I am only Manoj relying on the expression of the author. Manoj, I am not relying on the judgment from that book. The judgment that I have Manoj, I have taken out from the SEC online.
the impression of the author. Fifth edition.
Fifth edition.
সেটা না আমি যে সেটা তো জজ তো ভালো লেগে এটা কমন yes that is all
yes
what about non-joinder of the daughter
Joinder of necessary parties, my lord, the daughter, my lord, is was cited as a witness. My lord, as of today, my lord, the daughter, my lord, knows, my lord, a suit is pending and eviction suit is pending. My lord, she has not chose, my lord. On that point, I will be relying upon. I did not expect that. I did not take out print, my lord. My lord, lordship knows Nasima Naki's judgment, my lord, of the division bench of Justice Sanjeev Banerjee. Now, my lord, right of preference. My lord, she has not exercised. My lord, either she could have preferred her leave to appeal before this. I was a necessary party because my learned friend's client being the husband, my lord, he cannot espouse the cause of the daughter. And being the daughter, being my lord, an adult daughter. One. Number two, my lord, I should not say so, but my lord, daughter also have a remedy under Order 21, Rule 99, 100, 101 for adjudication of that. Because here, my lord, in this appeal, my lord, my learned friend has to confine himself, my lord, with his defense.
but whether the suit is bad for non-joinder of the daughter
Whether the suit is bad for non-joinder of the parties. Now, my lord, suit
without the daughter you directly file against someone who is not who falls under 2G.
My lord, whether my lord defendant can, my lord, argue that. Being, my lord, plaintiff being the dominus litis, my lord, whether the defendant can argue that, whether the court can, my lord, force upon that in view of, my lord, Order 1, Rule 9 of the court. If my lord, court, my lord, learned trial judge was of the opinion, yes, daughter was a necessary party. First of all, my lord, then could not have been dismissed, my lord, without giving an opportunity to add them. My lord, he only said the only defense in the written statement was, what was the defense? All necessary parties have not been made parties in the suit. Who are the necessary parties, my lord, not stated. They, my lord, come, they cite as a, my lord, daughter, my lord, as a witness. Still, my lord, daughter doesn't think fit to, my lord, get herself added in the suit. They did not raise this issue. That's why, my lord, at the time of argument or framing of issues, no issue was framed on this. And this is, my lord, not, my lord, completely, my lord, an issue, my lord, of law. This is on facts. This has to be, my lord, raised. My lord, who is a necessary party, my lord, nothing, my lord, said. Now, my lord, regarding, my lord, my lord, the proviso to 2G, the first proviso is also there. My lord, 2G, my lord, is not, kindly see, my lord, the first proviso. Whether he can be at all given, my lord, the 5 years time limit. First of all, there are two conditions, my lord, dependent upon him and ordinary residing him. Therefore, these are conjunctive. It's all these conditions have to be satisfied. Now, my lord, the proviso. Proviso is the third condition. Kindly see, provided that the time limit of 5 years shall not apply to the spouse of the tenant who was ordinarily living with the tenant up to his death as a member of his family and was dependent upon him and who does not occupy any residential premises. My lord, the three, my lord, criteria have come up, my lord, the truth has come up in the cross-examination. One. Number two, my lord, my learned friend, my lord, had relied upon, my lord, 6.1d. My lord, 6.1d is for the landlord, not for the tenant. My lord, kindly reads, my lord, 6.1d. Very well.
Read it sufficiently,
Very-
sufficient number of times.
It is the landlord does not have any premises within the 10 kilometers or within Kolkata Municipal
Wants to draw an
Corporation.
analogy between alternative accommodation, availability of alternative accommodation on that count. That also speaks of alternative accommodation. This also speaks of, like, with due respect, Rabindranath Tagore's beard and the other beard. It's an analogy of that sort. So therefore,
But analogy can't be drawn because this was for the
there also analogy cannot be drawn. It's a fallacy. of
this
logic.
is what
That you learn friend knows very well.
and my lord, judgment bar karo justice Nasima Nakim.
For what proposition?
My lord, 2G, my lord, general proposition of law, my lord, it was laid down, my lord, kindly.
Don't cite a judgment for citation's sake.
No, my lord.
See, 2G itself lays down the whatever is there in 2G. Why should we read a judgment for that?
My lord, for the my lord, kindly see, my lord, if I may read paragraph 21, my lord.
You read out.
Even if the limited rights conferred on the heirs of the original tenant by the second proviso to section 2G of the Act were to be read to also be applicable to the spouse of the original tenant, such rights would not be enough to resist an eviction decree sought by the landlord against the spouse in respect of the premises let out for non-residential purpose after expiry of 5 years after the
This
date
is
of
not
the-
non-residential.
Oh, Miller residential also come. Miller, it has been said, Miller, the Causa Omissus principle has been Miller applied, and it says ultimately says that the same ratio will apply to Miller residential also.
Probably it is the other way around.
It's the other way around.
It's the other way around. Residential by default it applies.
But kindly, Miller, kindly.
Because if he was not residing, ordinarily living with the tenant, it has to apply to a residential by default. There probably it was the contrary was held. That cases omissus, therefore this it applies to non-residential also. Here it's not a question of non-residential.
And Millard, their affidavit says Millard business. The written statement says Millard the business dependency factor Millard subject to correction Millard does not apply. Kindly see the written statement.
Affidavit in chief.
What about the written statement?
Page 20.
Yes. What about that?
Millard dependence by occupation of business. Page 20, the affidavit portion of the written statement.
Yes.
And Millard, my learned friends with the Madhuri Jaiswal's death certificate, Millard, the permanent residence of Ashok Jaiswal, also Millard, that is annexed there, Millard, it says Millard 9 Belilias Road. This is Millard.
Very possible. The present appeal has been preferred against the judgment of eviction of the appellant on the ground that the appellant came within the appellant was not a tenant in respect of the suit premises within the contemplation of section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997 bracketed for short the 1997 Act bracket close. Puts up next parallel and counsel for the appellant argues that the essential ingredients for being excluded under section 2 within bracket small g and its proviso from the definition of a tenant were not pleaded in the plaint. Puts up next para as such, it is contended that if in the absence of such pleadings, the learned trial judge erred in law in looking into the evidence, since no amount of proof beyond the pleadings can be looked into by the court. For sub next para, learned counsel cites Sri Udhav Singh versus Madhavrao Sindhia, reported at 1977 1 SCC 511, in support of the proposition that the material facts, as contradistinct with material particulars, which lead to the cause of action for filing a suit, are essentially to be disclosed in a plaint, semicolon. In default, the plaint is liable to be struck off under Order 6, Rule 16 of the Code of Civil Procedure. So, sub next para. In the present case, the plaintiff stroke respondent merely stated in the plaint that on the death of Madhuri, the original tenant, who was the wife of the present appellant, the tenancy was extinguished, and that the plaintiff was entitled to eviction against the defendant stroke appellant within the contemplation of section 2 small g of the 1997 Act, without disclosing any further particulars. For next para, thus, it is submitted that the principle laid down in Sri Udhav Singh Supra are attracted. For next para, secondly, learned counsel contends that the daughter of the original tenant, Madhuri, who was admitted to be residing with her mother at the time of the latter apostrophe's demise, was not implicated as a party to the suit, thereby making the suit liable to be dismissed for non-joinder of necessary parties. For next para, learned counsel cites such and such reported at 2022 SCC Online SC 1307 in support of the proposition that a necessary party is a person who ought to have been joined as a party and in whose absence no effective decree could be passed at all by the court. If a necessary party is not impleaded, the suit itself is liable to be dismissed. Next para. Thirdly, learned counsel argues that despite the defendant stroke appellant having furnished his Aadhaar card and electricity bill to show that the defendant stroke appellant has been in possession of the suit premises at the relevant juncture, the learned trial judge came to the perverse finding that the appellant was ordinarily residing elsewhere, at 9, Belilias Road, Howrah. Next para, it is argued that the legal effect of the Aadhaar card and the electricity bill was completely overlooked by the learned trial judge. Next para, furthermore, at least one rent receipt was produced by the defendant stroke appellant to indicate that rent for certain months rent receipt for certain months were issued by the plaintiff stroke respondent in favor of the appellant as well as the son and daughter of the original tenant, thus admitting that the appellant was a joint tenant in respect of the subject property. The same was disbelieved by the learned trial judge merely on the ground that it was manufactured, by placing reliance on other rent receipts produced by the plaintiff stroke respondent for a period which coincided with that reflected in the receipt produced by the defendant stroke appellant. Such finding, it is argued, was also illegal and perverse. Next para, learned counsel places reliance on SP Sengupta's book on West Bengal Premises Tenancy Act 1997, 5th edition, within bracket 5th edition, to argue that as per the author of the said text, The word ordinarily, double inverted clause, used in clause small g within bracket of section 2 of the 1997 Act clearly signifies that permanent living with the tenant up to the date of death of the tenant is not necessary. Full stop. Next para. By placing reliance on the commentary section of the self-same book, comma, learned counsel for the appellant argues that in order to be a dependent, double inverted clause, within the contemplation of section 2 within bracket small g, comma, such term need not be interpreted necessarily in the context of financial dependence. Full stop. The author of the said text, comma, inter alia, comma, opined that the word dependent, double inverted in the legal parlance means quote unquote deriving existence, comma, support or direction from another, triple dot inverted clause, and that the word dependence within bracket within double inverted means open quote a state of looking to another for support, comma, maintenance, comma, food, comma, clothing, comma, comfort and protection of a home and care, inverted clause, comma, one who gets protection of a home and as such can also be considered as a dependent of the person who gives him such protection. Full stop. Thus, comma, dependency is independent of any financial help. Full stop. Next para. Learned counsel argues that, comma, as such, comma, the mere stray admission of the plaint, defendant stroke appellant in his cross-examination to the effect that he has a business need not necessarily imply that he was not dependent on his spouse, comma, the original tenant. Full stop. Next para. Even otherwise, comma, although certain documents might have been produced or admitted by the appellant, which indicate that the appellant also had a residence at 9 Belilias Road, Howrah, comma, that is elsewhere than the suit premises, comma, it did not necessarily mean that the appellant was not double inverted ordinarily, inverted clause, residing with the original tenant during her lifetime until her demise at the suit premises. Full stop. Next para. Thus, comma, it is contended that the impugned judgment ought to be set aside. এই লাইনটার আগে আরেকটা প্যারাগ্রাফ অ্যাড হবে। It is further argued, comma, also by placing reliance on the book referred to above, comma, that the alternative accommodation contemplated in section 2 within bracket small g of the 1997 Act has to be read on a similar footing as that mentioned in section 6 within bracket 1 within bracket small d of the said Act. Full stop. Seen thus, comma, the said alternative accommodation has to be within an area of 10 kilometers from the suit premises and within an area where the Act extends. Full stop. In the absence of any proof in that regard, comma, it is submitted that the accommodation of the appellant in Belilias Road at 9 Belilias Road, comma, even if true, comma, could not be a determinant of whether the appellant was covered by section 2 within bracket small g. So next para, learned counsel appearing for the plaintiff stroke respondent categorically controversy arguments of the appellant and points out that the defendant stroke appellant clearly admitted in his cross-examination that he does business, comma, which fact was borne out by the affidavit in support of the written statement of the appellant as well. Full stop. The appellant further admitted in his cross-examination that he has cast his last vote from premises number 9 Belilias Road, Howrah, and that except the Aadhaar card, in all his documents, comma, the address was given at 9 Belilias Road, Howrah. Full stop. Next para. It is further argued by learned counsel for the respondent that the appellant also admitted in his cross-examination that he did not file any document to show that he was residing in the suit premises during the lifetime of Madhuri Jaiswal, his spouse, within bracket, the original tenant. Bracket closed, full stop, next para. Moreover, learned counsel argues that the appellant cannot espouse the cause of his daughter, to whom it was open to take recourse to appropriate legal remedy if she was entitled to retain possession within the contemplation of section 2 small g bracket of the 1997 Act. Full stop, the daughter, in fact, adduced evidence as one of the plaintiff's witnesses in support of the case of the appellant, but never took the plea that she was independently entitled to protection as a tenant under the 1997 Act. Full stop. Next para, thus, the argument of non-joinder falls flat, it is submitted. Full stop. Next para, with regard to the documents produced before the trial court, learned counsel points out that from the death certificate produced by the defendant stroke appellant himself, it would be evidence that his permanent residence was not the suit premises but 9 Belilius Road. Full stop. Next para, insofar as the purported rent receipt produced by the appellant, it would be clear that the same was written at one go, covering several months and coincided with a period for which counterfiles of rent receipts had also been produced in evidence by the plaintiff stroke respondent, the veracity of which was never challenged by the appellant. Full stop. Next para, thus, it is argued that the learned trial judge was justified in passing the infirm judgment. Judgment side you cited a judgment.
Refer to Tasimana given.
Oh, no. Thank you. Next para. Upon hearing learned counsel for the parties, we find substance in the contention of the respondent. Full stop. Next para. Insofar as the contention of the appellant that the necessary ingredients of section 2 within bracket small g of the 1997 Act were not pleaded by the appellant, by the plaintiff stroke respondent in the plaint, there is no statutory requirement to separately plead the ingredients as embodied in section 2 within bracket small g. Full stop. It is sufficient if the rudiments of pleadings are there, which are subsequently substantiated in evidence during the trial. Full stop. Next para. After the evidence, after both parties led evidence and the suit was decided finally on a full-fledged trial on evidence, the question of whether some ingredient of law or the other was not pleaded in the plaint becomes rather academic. Full stop. In the present case, both parties were confronted with the issues involved in the suit and argued on the same, leading evidence in support of the respective cases. Full stop. Having not taken such objection at any point of time, it does not lie in the mouth of the appellant now to raise such issue for the first time before the appellate court. Full stop. In paragraph number 1 of the plaint, it was categorically pleaded that one Madhuri Jaiswal was a recorded tenant in respect of the suit premises. Full stop. In paragraph 2 thereof, it was pleaded that Madhuri Jaiswal died and after her demise, tenancy held by her has been extinguished under the provisions of section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997. Full stop. Such pleadings were sufficient for the purpose of leading evidence on whether the ingredients of section 2 within bracket small g were satisfied. Full stop. It was not the case of the plaintiff stroke respondent but the positive assertion of the defendant stroke appellant that the latter ought to have been granted the benefit of section 2 within bracket small g, comma, since he was dependent on his spouse and he had been living with his spouse, comma, the original tenant, comma, at the time of her demise, comma, at the suit premises, and had been ordinarily living at the said premises with her. First up, it was also to be established by the defendant stroke appellant, comma, who positively asserted such status, comma, that he fulfilled all the conditions as stipulated under section 2 within bracket small g. Push up next para. In the present case, comma, the defendant stroke appellant himself, comma, in his cross-examination as DW1, comma, categorically demolished whatever case he sought to make out in defense. First up, as to the first ingredient of dependence, comma, the appellant admitted that it is a fact that he does business. Push up, the self-same fact was reiterated on oath in the affidavit filed in support of the written statement of the defendant stroke appellant in the trial court. Push up, next para. Thus, comma, the ingredient of dependence on the spouse was not made out. Pushed up with utmost respect, comma, the authority sought to be derived by the appellant from the text placed before us is misplaced. Full stop. The said authority has not acquired such an elevated status, comma, with due respect, comma, that the same can be cited as a settled proposition of law. Full stop. We have full regard to the opinions expressed by the author in the said text, but nonetheless, comma, those remained only the opinion of the author and did not have the authority of law behind it. Pushed up, we cannot agree with the extreme proposition that the expression double inverted dependent, double inverted clause, used in section 2 within bracket small g can be extended to such a limit that the dependency would traverse beyond the financial element of the same and also extend to a psychological or an extraneous level, comma, completely divorced from the finances of the dependent. Full stop. Next para. The term double inverted dependent, comma, as understood in law, comma, has either to be relatable to the categories of dependents as provided in the Succession Act, comma, for example, the Hindu Succession Act, or alternatively, comma, has to have a financial context to it, comma, there being a dependence between the dependent and the person on whom he or she is dependent, comma, insofar as financial support is concerned. Full stop. In the absence of the same, comma, we have to construe the word dependent in section 2 within bracket small g completely in its financial context. Full stop. From such perspective, comma, in view of the admission of the occupation of the appellant, comma, we are unable to accept that he was financially dependent on the original tenant, comma, his wife. Full stop. Next para. Even dependence of any other sort is not evident, comma, at least from the cross-examination of the appellant, comma, since the appellant categorically admitted that he had cast his last vote from a different premises than the suit premises, comma, where his wife was living during her lifetime, and also that except Aadhaar card, comma, all other documents in the possession of the appellant showed his address to be 9 Belilias Road, Howrah, comma, which was not the suit premises where his spouse resided during her lifetime. Full stop. Thus, comma, the other extended elements of dependency, comma, although not relevant, comma, are also not attracted in the present case. Full stop. Next para. With regard to the argument of the appellant as to the expression double inverted ordinarily decided double inverted clause, not necessarily referring to permanent residence, comma, even going by such proposition, comma, the ordinariness double inverted মধ্যে of the residence has to be seen in the light of some element of permanence insofar as the intention of the concerned person to reside at a particular place is concerned. Full stop. From such perspective as well, comma, we find that the appellant unequivocally admits in his cross-examination that he cast his last vote from a different premises than the suit premises, and all his documents apart from the Aadhaar card pertain to the other premises. Full stop. He also admitted in his evidence that he did not file any document to show that he was residing in the suit premises at all during the lifetime of Madhuri Jaiswal, comma, his wife and the original tenant. Full stop. Thus, comma, such ingredient of section 2 within bracket small g is also not satisfied. Full stop. The suitability of the accommodation as provided in section 6 within bracket 1 within bracket small d is completely different and operates in a distinct and different field than that from which it is used in section 2 within bracket small g. Full stop. Whereas section 6 within bracket 1 within bracket small d furnishes a ground for eviction in the event the tenant has a suitable accommodation within 10 kilometers from the suit premises, comma, such qualification is utterly missing with regard to the alternative accommodation as mentioned in section 2 within bracket small g. Full stop. Since the legislature, comma, in its wisdom, comma, deliberately dropped the other qualification from the definition of from the mention of alternative accommodation in section 2 within bracket small g, comma, we cannot, comma, as a court, comma, read something into the statute which was not intended to be there by the legislature. Full stop. Thus, comma, we have to look into the alternative accommodation as contemplated in section 2 within bracket small g, comma, with in its first proviso bracket closed, comma, in the literal sense of the term and not import the 10-kilometer radius into it. Full stop. Next para. Hence, comma, the admitted residence of the appellant at 9 Belilius Road at all points of time takes him outside the purview of section 2 within bracket small g on such count as well. Full stop. The ratio laid down in Moreshar Yadarao Naftakedu Mahajan, এটা 2022 SCC online SC 1307. In regarding non-joinder of necessary party is a well-settled proposition and there cannot be any quarrel with the same. Full stop. As per the Code of Civil Procedure itself, comma, a person who ought to have been joined as a party and in whose absence no effective degree could be passed, comma, if not impleaded, comma, the suit itself is vitiated. Full stop. However, comma, the daughter of the original tenant adduced evidence as a witness in the present case in support of the appellant, but at no point of time either sought to implead herself or made any independent claim of coming within the purview of section 2 within bracket small g of the 1997 Act, comma, claiming tenancy through her mother, comma, the original tenant. Full stop. In order to establish a person to come within the purview of the same, comma, he or she has to assert such right and prove the foundational ingredients to come within the purview of the said definition of a tenant. Full stop. The daughter of the appellant and the deceased original tenant, comma, despite having full knowledge of the suit, comma, adduced evidence therein and having opportunity to do so, comma, never sought to either impede herself or to assert in any manner her independent right as a tenant under section 2 small g within bracket. Thus, comma, we cannot permit the appellant, comma, that too at this belated stage, comma, to espouse the cause of his daughter on a footing which is independent from that of the appellant. Full stop. Next para. Hence, comma, we do not find the daughter to have been a necessary party at all on the basis of the pleadings of both the parties as well as the frame of the suit. Full stop. Next para. Insofar as the reliance of the appellant on his Aadhaar card is concerned, comma, it is well settled that an Aadhaar card is not a conclusive proof of either citizenship or residence. Full stop. At best, comma, the same may create a prima facie presumption, comma, which is rebuttable in law. Full stop. The presumption, comma, even if any raised by the Aadhaar card produced by the appellant, comma, was demolished convincingly by his own cross-examination and his admission that all other documents showed that he did not live in the suit premises at all. Full stop. Next para. The purported rent receipt produced by the appellant indicated that the same was issued at one go, comma, a single receipt covering different periods, comma, including the months of November and December 2018 and January to September 2019, comma, without any clear explanation as to such issuance. Full stop. Next para. The learned trial judge, comma, on facts, comma, came to a finding that the said document was not credible. Full stop. We do not find any reason to reverse such finding of fact simply because another view is possible. Full stop. Next para. The appellant also seeks to rely on the deposits of rent before the rent controller by the appellant. Full stop. However, comma, such unilateral deposit by the appellant does not create any special right or equity in favor of the appellant. Full stop. The rent controller, comma, within the purview of the 1997 Act, comma, is not authorized in law to decide the tenancy of a person or to give a declaration to that effect, comma, which is reserved within the exclusive domain of the civil code. Full stop. Next para. Thus, comma, the acceptance of deposits made by the appellant by the rent controller did not create any legal right which did not vest in the appellant in the first place. Full stop. Even otherwise, comma, we do not find any substance in the contention of the appellant that the absence of pleadings in the plaint as to the ingredients of section 2 within bracket small g vitiate the suit itself, comma, particularly since both parties laid evidence substantially on the same. Full stop. The reliance of the appellant on Sri Udhav Singh Suprak is also misplaced, comma, since the said judgment was rendered in the context of an election petition, comma, where the trappings of the Code of Civil Procedure are also applicable. Full stop. The pleadings referred to in paragraph number 44 of the said judgment, comma, categorically were in the context of corrupt practices under the appropriate statute. Full stop. Next para. Since such fraud and corrupt practices required particulars of pleadings akin to Order 6, Rule 4 of the Code of Civil Procedure, comma, the Honorable Supreme Court discussed the said provision as well, comma, in the context of Order 6, Rule 2 of the Code. Full stop. In such perspective, comma, it was held that it was vital that the corrupt practice charged against the respondent should be a full and complete statement of material facts to clothe the petitioner with a complete cause of action and to give an equal and full opportunity to the respondent to meet the case and to defend the charges. Full stop. In the present case, comma, the yardstick is preponderance of probability as opposed to charges of a criminal nature. Full stop. It is right law that the law is not required to be pleaded in the plaint or the written statement. Full stop. It would suffice if the necessary factual premise for invoking particular provisions are disclosed in the plaint. Full stop. In the present case, comma, thus, comma, sufficient rudimentary ingredients were disclosed in the plaint and substantiated not only from the evidence by the evidence of the plaintiff stroke respondent, but convincingly and clinchingly by the evidence and cross-examination of the defendant appellant himself. Full stop. In such view of the matter, comma, we do not find any merit in the appeal. Full stop. Accordingly, FA 97 of 2026 is dismissed on contest, comma, thereby affirming the impugned judgment and decree dated January 16, 2026, passed by the learned 10th bench, learned judge, 10th bench, City Civil Court at Calcutta, in title suit number 111 of 2022. Full stop. There will be no order as to cost of formal decree be drawn up accordingly. This stay application was also pending.
Yes.
Can such and such is also disposed of consequentially. Yes. Okay.
Number 5.
Up to 9. Still,
5, my lord, I appear for the state, my lord.
State.
For the respondent number 2.
Oh, yes.
In fact, they were directed to pay court fees. I don't know whether they have cured that.
You have cured the defect.
I do not know whether they
Yes,
have.
my lord.
Court fees were to be deposited,
Yes, my lord.
deficit court fees.
We'll be giving within 2 weeks.
You are given time.
Being-
You are given time.
Here,
You have not yet deposited.
court fee and not deposited, my lord.
2026.
Recently filed, my lord. That's why.
Of June 2026, they were directed.
If you just-
Registrar administration. We extend the time for they are enjoying an interim order. Are they enjoying an interim order?
No, no. My lord, since if it commences to a lordship, it pertains to a land acquisition. My lord, they were agreed with the amount of compensation which was awarded by the LA. They preferred a appeal under section 20. It has been enhanced. They are not happy with that. Against that, they have
Section 18.
I'm sorry, ma'am. They have preferred this appeal.
Read that into
The
yourself.
entire paper, the records, your lordship knows that unless they had complained about the compensation which was awarded by the LA, they could not have it filed it before the district judge. The entire records may be brought before your lordship.
Hey, LCA will be definitely.
The entire records of the acquisition
will come. Has to come. What is your application for?
For appropriate order, my lord. Some modification required, my lord, of the impugned judgment and degree. Impugned judgment and degree.
Will modify at this stage.
Some actually the value, the value which the LA court assessed, my lord, that is totally unfair in the Shali class of land. 2 class of land was acquired, my lord, one Danga and
That
Shali
will
class of
apply
land.
on merits.
Yes, ma'am.
How
That
can
is,
now?
that is.
But you have not yet deposited the court fees.
It's your lordship.
Deposit court fees. We'll grant you 2 weeks time. We're disposing of this application. There is no scope of passing any order. This pertains to the merits of the appeal. We'll pass the usual directions. Mr. Chaturvedi, you are appealing for the state.
Yes, my lord.
And
My lord, on reference,
yes,
the compensation was enhanced. He is yet dissatisfied and has preferred a
once
appeal.
more. So requiring body or anyone else is required to
No,
be.
no.
Who are you for?
I am for WBIDC. I am the acquirer.
Oh, you're the
recording body.
Very well. So all are appearing. So we'll dispense with further service of notice and we'll. Can 1 of 2026 is an achana. Prathome ekta, on the prayer of learned counsel for the appellant, comma, the time for depositing deficit court fees is extended for a fortnight from date. Full stop. In default, comma, the matter be listed under the heading Lawzima for final orders. Full stop, next para. Can one of 2026 is an application for appropriate orders? Full stop, from the prayers thereof it transpires that those pertain to the merits of the appeal itself. And as such, comma, it would be premature to pass any directions as prayed for. Full stop. Accordingly, can one of 2026 is disposed of, comma, by directing the trial court records to be brought by special messenger at the cost of the appellant, to be deposited within a week from date, full stop, in view of the appearance of all the respondents through their respective counsel, comma, service of notice of the appeal on the respondents is dispensed with, and the appeal be treated to be ready as regards service. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to mention the appeal for inclusion in the list as and when the same is ready for hearing. No less to mention. Affidavit of service filed to be kept on. If you don't deposit within a fortnight, then comes up at lodging for final orders, we'll dismiss it.
Right, item number 8, I'm for the stay.
Item number
8. 5 to 9.
5 to 9 same analogous matter.
Nine, my lord, same.
Appearing differently.
So just give your names, which item you are appearing, and the names corresponding names.
For 6, my lord, I am appearing.
Yes, need not file a hajira. Just on a slip of paper, you just write. Yes. Thank you. Grateful, madam. Thank you.
Item number 9.
10.
9 টা লিখে দিন আপনি নামটা লিখে দিন হয়ে যাবে
10 who is appearing? Not to the court. 10 একটা order record none appears for the parties. Let the matter stand adjourned for the day.
Lordship, item number 10, I've just been instructed Mr. Dutiman Banerjee is appearing. Is engaged in courtroom number 650.
You have recorded none appears. You're for the responding to any email. Yes.
I appear for the respondents.
Respondent. Yes.
Led by Mr. Shonak Mukhopadhyay, he's on his feet. Can I get a
Can't hear you, use the microphone. You are Mr. Ganguly?
Yes, I'm led by Shonak Mukhopadhyay. He's on his feet. Can I get a short pass over, my lord? I'm asking for
2 days.
I know. Look at the words.
Just 2 minutes. Can I just call?
Call it. Pass over.
It will take some time, my lord. So it is
So
better.
then let it be not today.
Not
Not today. An accommodation is sought by the appellant. Let matter stand adjourned for the day.
Item number 12.
My lord, I appear for the appellant in this matter.
Well,
Lord,
well,
you will
Lordship,
recall,
I'm
my
for
lord,
the
this is the matter, my
respondent.
lord.
I'd be praying
Well,
for,
my lord.
not today because I'm led by Mr. Anuruddha Chatterjee in this matter. Is engaged in courtroom number 9.
He will not oppose Mr. Anuruddha Chatterjee.
Only thing is, on the last occasion, there was a direction for affidavits. Let that be taken on record.
Yes, my lord, affidavits have been exchanged, my lord. May I file my reply, my lord?
Yes. What is your opposition? The affidavits in opposition and reply filed to be kept on record. Full stop. On the prayer of the respondent, the matter is adjourned for the day.
My lord.
Good.
नाम तो दिए थे तीनों चल
Item number 30.
Lordship, I'm for the petitioner.
Refuse. Move the matter.
There's a defect that we have not submitted the lower court's order. So I'm praying that 2-week accommodation so that we can file it.
No, then it goes out of the list. You file that and mention again. Learned counsel for the appellant seeks a fortnight's accommodation to file the certified copy of the trial court's judgment and decree. Full stop. Let the matter go out of the list with liberty to the appellant to mention the same as and when such certified copies are filed in the department. The department shall file a revised report upon such certified copies being filed. File it in the department, they'll give a revised report, then mention.
We'll mention it.
I appear for the petitioner.
Yes. Lord, I have instructions to appear, my lord. For the rest.
Caveat was there.
No, caveat was.
Lord, explanation of delay, my lord, I have 2.
My lord, only
So this have to be
injunction.
the postal costs are saved.
Injunction. My lord, only one thing, my subject to correction, my lord, I have not seen the order. My learned friend, my lord, is challenging the ad interim order of injunction. Now, my lord, in the meantime, my lord, the hearing of the main injunction application is complete, and my lord, it is fixed on 7th of September for orders.
Then will not interfere. You take instruction on that. Learned.
Manobabu hearing kore diyeche.
You are appearing.
Plaintiff, defendant, respondent.
Although there is no although no caveat was lodged, comma, since learned counsel having instruction to appear for the defendant respondents appear and seek a copy of the papers, comma, the learned advocate for the appellant shall serve copies of the applications as well as a copy of the memorandum of the appeal on the learned advocate for the respondents. During the course of the day, can you do it?
By tomorrow.
By tomorrow. By tomorrow, full stop, next para. Learned counsel for the respondents also submits that whereas the present appeal has apparently been preferred against an ad interim order, comma, the main injunction application has been heard by the learned trial judge in the meantime, and orders have been reserved on the same, comma, the next date being fixed on September 7, 2026. Full stop. Learned counsel for the appellant is requested to take instruction on such count as well. Full stop. Next para. Let the matter be listed next under the same heading on August 24, 2026, Monday. Respondent.
Respondent.
May it please, your lordship.
15 and
My lord,
16.
I appear for the appellant in this matter. Your lordship will pardon me for appearing virtually, my lord.
Can't see you. Who are you?
My lord, my Tanish Ganeriwala, my lord.
Yes, now I can
Camera.
see you. Yes.
I'm so
Yes,
sorry,
yes,
my
yes.
lord, for appearing
No, it's
virtually.
fine. No difficult.
My
Yes, what
lord,
is the matter?
your lordship will recall this matter was last taken up on the 15th, my lords, wherein 17th, I'm sorry, wherein your lordship, my lord, had directed the
You're my
respondent.
namesake, that is what I'm saying. Yes. Yes, sorry, Mr. Please
My
continue.
lord, your lordships had directed the respondents of to contemplate a possible settlement, if at all, my lords, and to take
What about
instruction
that?
insofar as that is concerned, my lord.
Yes, Mr. Bhattacharya, what is it?
But the question of settlement, but the agreement, if in respect of item number 16, if my lord takes, there was a service agreement which has already expired. Even after expiry of the service agreement, they are accepting the rent. So we had filed a suit for declaration that we are the monthly tenant in respect of the property.
Comes to Mr. No difficult. You are competently represented. Yes.
After expiry of the service agreement, we are paying the rents.
Service agreement means?
It says it has been termed as a service agreement. We are occupying some spaces of the plaintiff.
You are the occupant.
Occupant. It's a leave and license agreement for 11 months. If my lord takes up the agreement once.
No, this is the challenge has been preferred by them
against the ad interim expert injunction order.
Injunction restricting them from disturbing your position?
No, from maintaining status quo.
Peaceful position.
No, I won't say the same thing. What right do you have to the premises?
But we are paying the rents after expiry of the license agreement.
Live-in license is, can there be tenancy at sufferance?
Not
a live-in license.
Tenancy at sufferance, not my lord.
My learned friend, that document should not have been annexed. The agreement which he is referring to, because it's not part of trial court record. No, I can't. I don't want to break ducks and drakes, man. That document is a leave-in license agreement as he fairly submits, but the injunction was obtained on the basis that he's a tenant by showing documents which are styled as rent receipts.
Reconciliation is your only chance, probably.
If my lord,
I am aggrieved because my lord, direct status quo. I can't even revoke license.
No, if there is a consensus, I mean, if the mentor suit maybe.
No, if he's saying, well, that's what I thought. He's running in practice from there, I didn't. So if he wants some time, there's no difference.
Oh, he's an advocate.
Number 626 is an advocate.
16.
I'm sorry, 16 is an advocate. His practice is there. He pays about £1 lakh of rupees as rent.
To an understanding, but
it's just a matter of whatever time.
Mediation is it?
One of them is threatening us with cases under the SC/ST Act. The previous matter, number 15. SC/ST is non-bailable, it's very serious, my lord. Here, my lord, it's lack of subject matter jurisdiction.
Why? Why do you
Commercial tenancy or commercial whatever, commercial use, and rent paid is 1 lakh. It's valued as 200 rupees for declaration, injunction, simpliciter. So it's a commercial suit, then section 12 of the specific value is the value of the immovable property.
Used for a commercial purpose?
Yes, admitted.
No, advocate's chamber is not a commercial.
No, he says commercial tenancy in the plaint. He says commercial tenancy. Just see my lordship will have
an ordinary civil court. I mean,
Yes.
not a commercial.
And valued at that suit value is court fees act 200 rupees declaration, injunction. So that valuation doesn't work.
No, specified value is different from
I
court value,
follow.
suit
So
value.
this- Now, my lord, kindly see.
We have to go by the specified value.
Yes, so that is how it has to be valued.
Yes,
And if it is false, if it is
Once you show that it's a commercial
yes, it
dispute,
is. Kindly have, my lord.
Paragraph 5 at page 34 of the stay, sir.
Yes, Mr. Ganirwal, I'm there. Thank you.
Yes. Yes.
Paragraph 7 at page 35, my lord. Second suit diya hai to.
Paragraph 7 at
Page 35, my lord, is the plaint.
Item number 16.
Item 16, PKS India Legal LLP. Your lordship perhaps has the previous.
wrong one, as usual.
And the sec of no. And in
Every time you do that. Paragraph 7 from the very beginning.
which is very common in practice for commercial tenants. I will go by the averments made in the plaint.
Very happy to do that. We'll be very happy to do that. For a change. Go to the apartments of their plaint. Obviously will.
Well, it kindly,
This is very clear.
and kindly come to how the valuation is done. Well, paragraph 26.
This valuation, we don't know why people submit on this valuation. Suit valuation is something else from specified value.
Yes.
Dispute, commercial dispute is there. Then specified of specified dispute is of specified value, not
Yes.
the suit.
No, not the suit. Yes.
The suit.
And one of the Commercial Courts Act,
That's
then
no connection with that.
specified value is the value of the immovable property. It overrides, my lord, the Court Fees Act and Suit Valuation Act
Yes,
as
we'll allow the appeal tomorrow. We'll allow the appeal tomorrow.
on lack of, my lord, only subject matter jurisdiction and suppression are other
on that
things.
ground itself. If not on any other ground.
But I was hoping that I know Mr. Boralman, I was hoping he would prevail upon his client because now the relation is so sad with police complaints, SC/ST Act.
We also cannot take the risk.
Yes,
we
but
cannot
if
give
he
you
can,
protection
if he can
you-
prevail upon his client.
Even Mr. Boral cannot, he doesn't have control over that.
No,
He
that
cannot
is
assure you that they'll not.
No, but reconciliation as in they want
No,
some.
that's different.
Yes.
I mean,
Time to vacate, we can agree.
there
my
is
lord.
no reconciliation. He cannot assure you that his client won't be.
No, that
Okay.
whatever criminal procedure will follow, my lord, that is.
So we record that you are not agreeable to reconciliation.
No.
That charge was given to you. No, don't be shy about it. You are your creature of instruction.
No.
Previously, it transpired that there was a possibility of settlement between the parties. So, however, at the time of call today, learned counsel for the respondents. You are appealing for the respondent in both the appeals. Respondent in each of the appeals submits that there is no chance of reconciliation. Accordingly, the matter be listed tomorrow under the same heading for hearing under Order 41 Rule 11 of the Code of Civil Procedure. The matter the appeals be listed tomorrow.
Grateful, man.
We'll dispose of the appeal probably itself.
Deep problems.